Welcome to the regularly scheduled session of the San Francisco Ethics Commission. We'll begin by taking the roll. Vice Chair Chu.
Here.
Commissioner Rennie.
Here.
Commissioner Kopp.
Here.
Commissioner, I'm sorry, Lee.
Here.
Commissioner Lee. New commissioner and old brain, so it doesn't go together too well. All of our members are here. We'll begin and we'll start with public comment on matters appearing or not appearing on the agenda. Please come forward.
Good afternoon. My name's Douglas Yep. It's my first appearance in City Hall in years. They finally gave me permission to come. First remark I would like to say is I'd like to put my comments to honor the life and work of Joe Lynn, who used to be here all the time. He gave me some very good advice before he passed away, and I promised Joe that eventually his wishes will come true. In the spirit of Elliot Ness, I would like to remind everybody present, also on TV, that the San Francisco FBI office is supposed to have a public corruptions unit. And if you don't trust the people at City Hall, you can feel free to contact them, and they will do as much as they can. And I would like to remind everybody, in the case of Al Capone, if you can't catch them in the front door, you certainly can catch them in the back door. And I think that Joe Lynn would like us to catch all of them through the back door if necessary. Thank you.
Thank you. Any further public comment on matters appearing or not appearing on the agenda? If not, we'll move to item 3. Discussion and possible action on the draft minutes for the Commission's August 28th. Oh, I'm sorry. Come right ahead, sir.
Excuse me, Chair. I just want to clarify, if I have comment on item number 4, should I reserve that until
Yeah, why don't
later?
you wait until we take up
Great.
number 4,
Thank
and
you.
then you can go to that. You're welcome. So now any discussion for possible action on the minutes for the Commission's August 28th, 2017 regular meeting.
Mr. Chairman,
Commissioner Kopp.
2 additions. Item number 2, public comment on matters. Let's end that second sentence with the words "is concerned."
All right.
And then I want to add a sentence on item number 11, which was at the end, last sentence, a comment by me, commented on a lawsuit, adding the words, first of all, that on a lawsuit that he is involved with against the governor of California, add the words, and Fair Political Practices Commission, which is the first named defendant. Ray, 2016 legislation authorizing California general law cities to enact public campaign financing provisions despite the ban of Proposition 73, a voter initiative adopted by California voters in 1988. I would like to add those 2 phrases.
Okay. Without objection, those items will be amended and those phrases will be added.
Move to approve the minutes as amended.
I'll second.
It's been moved and seconded. All those in favor?
Mr.
Aye.
Shen.
Any opposed? The minutes are unanimously approved. Let's move now to item number 4, continued discussion and possible action on proposed 2017 San Francisco Anti-Corruption and Accountability Ordinance that builds on the initial Proposition J revision proposal and amends the city campaign and government conduct laws. And we'll have Mr. Kundert.
Thank you, commissioners and members of the public. Thank you for coming today. As you know, for some background here, at the August 28th meeting, Chair Keene and the commission voted to have us consider several additional amendments to the draft presented to the commission at that August 28th meeting. In our memo here, as beginning in agenda item 4, page 1, explains the provisions that staff considered since the August 28th meeting, and I will summarize those briefly for you here today. So the first and the most major provision of this bill is a what in the August 28th meeting was known as the behest payment restriction. That was originally housed in sections 1.126 and 1.127 of the Campaign Finance Reform Ordinance. After discussions by the commissioners and concerned comment from members of the public and also interested persons meeting held subsequent to last month's meeting, staff worked with those comments and worked with those individuals in attempting to find some language that we could potentially allow for particularly nonprofits to be able to engage in the good works that they do in the city of San Francisco while still limiting and restricting what many see in the city as the appearance of corruption and corrupting activities. However, in doing the review and taking comments in good faith, we reviewed that provision and determined that it would best be provided as part of the Conflict of Interest Code rather than the Campaign Finance Ordinance. There's constitutional and legal reasons which I can highlight should there be questions about why that is the case. But for now, suffice it to say, we moved the provision to the Conflict of Interest Code whereby it now says that no public official, so including not only elective officials as it was in 1.126 and 1.127, but commissioners and board members would now be prohibited from making basically requests or solicitations that someone who is in front of them, who has business in front of their either their agency or in front of the elective official, that they would be prohibited from making requests for a third party unless some limited exceptions applied. So that is the sort of major provision and the major change. Again, the exceptions that we heard most poignantly in public comment were the sort of fundraising galas and those sort of items. So we attempted to have exceptions that meetings or events that were held and there were 20 persons in attendance, that those would be exempted from the ban. We also had a sort of a general public communication ban and an emergency relief ban, and those were meant to sort of highlight what staff found were sort of the key areas and items that were represented by nonprofits and other groups as being the sort of areas that may have presented them from being able to raise the money necessary for them to do the good works that they do in the city of San Francisco. So the other provisions, I will move on briefly now. And again, if the commission will recall, the other provision was another one of the provisions, I should say, was the citizen suit or citizen plaintiff provision. In the original proposition, revised Proposition J as presented to us, they would have amended our current structure of citizen suit that we have in a current law to allow for a 50% award. After doing some review, staff made some changes and amendments to that, and we determined that instead of those individuals basically being able to receive that money directly, that the commission would act as a gatekeeper, or that was our proposal at the time, and then they would be able to cover 25%. Based on Chair Keene's proposal and voted on by the commissioners at the last meeting, we amended that provision to mirror, as practically as possible the LA provision, which now requires that a citizen plaintiff to notice us, and if we don't respond within 60 days, that citizen can then file a civil suit, and they can recover 50% of the penalties as well as reasonable costs and attorney's fees. Again, mirroring LA law. The next provision was a review of the restricting fundraising activities by city board and commission members. As in the August draft, city board members and commission members were prohibited from doing certain fundraising activity for elective officials if that elected official had to appoint them or was in their approval path. That was expanded via Chair Keene's proposal to more closely mirror the provision in LA, which is a total restriction on any any board member or commission member from doing any of the prohibited fundraising activity on behalf of any elective official, whether they appointed them or not. The third sort of provision that the commission discussed it, but it wasn't voted on in the meeting, was the statute of limitations provision in CFRO. The statute of limitations provision, as it's currently written, is limited. The board is limited to a 4-year strict period. So if the violation occurs, then 4 years pass. There's basically nothing that the commission can currently do. We took a provision from state law which allows us to toll the statute of limitations if there is fraudulent concealment from the parties. So during the discovery or period or during the investigation by commission staff, the statute of limitations could be tolled beyond the 4 years if there was fraudulent concealment identified. Again, this mirrors what is in the PRA and what they use for administrative proceedings. And then as a last sort of note here, I just want to note to the commissioners on page 6 of the draft, there is a procedural overview on that page. If the commission was to vote on this evening, there are some options for the commission. However, for practical purposes, and because you need 4/5 vote, the Board of Supervisors need 4/5 vote to amend any provision of CFRO, and for us to, if it was required for us to put this measure on the ballot, a 4/5 vote would be required in that case. It would be, I guess, better, more practical for the commission to have those 4 votes to bring this forward. However, if that is not the prerogative of the commission, it could still be presented to an individual member of the Board of Supervisors on a simple quorum majority vote, so a three-person vote. Again, that would have to come back to us then to amend because a 4/5 vote of the commission is required to amend CFRO. So with that, I will answer any questions remaining from the commission.
Commissioners? Commissioner Kopp.
You mentioned the provision on page 6. You're talking about contribution disclosures?
Agenda item 4, page 6? Agenda item 4, page 6?
Huh?
Agenda item 4, page 6?
So here.
Oh.
Ordinance itself.
Your report.
Correct, the memo. That is the procedural overview.
Yeah, I see. All right, thank you. That's just information.
Yes.
Okay.
Commissioner Chu.
Yes, thank you, Chair Keene. So just as a general matter, both to my fellow commissioners and also to staff and to the public, my own view is that this is definitely a different draft from what we reviewed in August. And I'd like to make sure that we don't lose sight of the problem that we are trying to solve here, because I think the language is very detailed. I think it is a very complex issue. And I want to be sure that this is a solution that is appropriately tailored to the problem that we're trying to address. So just as an example, we're talking about eliminating the ability of city contractors or those who are seeking a city contract from contributing to elected officials' campaigns. So I would like to know, just as a matter of data, how big of a problem is this right now? So what is the problem that we are addressing here with this with this provision.
Well, the contractor ban has already been in the law since
Yes.
2003.
Oh, so now, I'm sorry, in terms of land use.
Again, so I highlighted it in previous memos because this sort of data wasn't available. It's a bit hard to determine. We've done some preliminary data that suggested that roughly 8% of people who had the sort of title of CEO, executive director, and whatnot gave contributions, but that was to all committees, so it wasn't specifically to candidate committees. So you would expect that number to be lower in that instance. But again, it's not just the actual quid pro quo corruption, it's the appearance of corruption which has been identified through a number of news stories which we've presented to the commission, and it's also presented in surveys through public comment. You've seen the people have presented whether they view land use matters and decisions as being part of the sort of corrupting process in San Francisco. So in addition to the news stories and public comment and sort of that initial drafted data that we have presented in previous drafts, you also just have the general notion and knowledge that there's sort of been a lot of concern and direction around land use matters in general, such that we know the city is a land use issues and items are very important to the members of the city. There's entire sort of subsets of YIMBYs and NIMBYs and other creative acronyms and fights over land use and the decisions of developers. So I think in addition to the sort of news stories that have presented items concerning land use developers and the corruption materials that we presented in previous meetings, I think that's sort of presented with a good base of starting point of knowledge for the fact that there's at least the appearance of corruption in the city.
Okay, so what I recall from the previous materials was, a long list of links to news stories, and so I don't. Can you give me, for my own edification, if you will, but also for education, can you give me an example of an actual pay-to-play or a quid pro quo or the appearance of corruption, so that if I were to go home today and explain it to my middle schooler son, he would understand what it is that we are doing here tonight, or discussing here tonight.
Well, I'm sorry, I don't have the news stories all in front of me, but you have the issue which was actually in the city of Oakland, but still in the Bay Area, of a contractor engaging in the sort of the conduct we're talking about, but in terms of the city of Oakland, but still, it was a Bay Area contractor. And again, I apologize, I don't have the news stories in front of me as we presented that material at the last meeting.
Commissioner Rennie.
I just have a couple of questions on looking at this draft ordinance, which is attached to your memo, agenda item 4. On page 19, I think it is, well, it starts on page 8, section 1.163.5. Distribution of campaign advertisements containing false endorsements. Why is that section deleted?
Because it's very likely unconstitutional. A number of circuit courts, the 8th, the 5th, and I believe the 2nd, have all had cases saying that basically false campaign speech has value. Whether we like to believe that or not, they have said that it does. And this is all based on a 9th Circuit case, U.S. v. Alvarez, not related to campaigns in particular, but stemming from, of course, if anyone remembers the details of that case, now I'm forgetting. Yes, the Stolen Valor Act. Thank you, Andrew. So it's, although we may view false speech as not having political value, the circuit courts and the Supreme Court of this United States have told us that it does. So this provision has likely long since been unconstitutional, so we're removing that to update our laws.
Even though it's been in the SFRO for years and never been challenged, and have we sought to enforce it?
As my understanding has been, there has basically an understanding that this provision has been unconstitutional, or at least likely so, such that it hasn't been enforced because of that concern. So it just makes sense to remove it now, so it doesn't continue to potentially cause the city money in the future.
All right, then turning to page 24, under the definition of solicit, it says solicit shall mean personally requesting a contribution. And then it goes on to say, from any candidate or committee, either orally or in writing. Why do you have that clause in there? Why isn't it sufficient? Because as I read some other sections, that definition of soliciting doesn't make any sense in those sections. Whereas, why is there any necessity? Why isn't it just soliciting shall mean personally requesting a contribution, period? And then when you get to the sections where it says you shall not solicit.
So I guess so you're concerned that this definition of solicit in the conflict of interest code is?
My concern is, and I should have pulled out the section, but when you're talking about some general language on past payments, let me just see if I find it.
Which subsection is it?
Well, this is page 19, but I've got to find I'm just questioning why it's necessary. In order to constitute a solicitation, it has to be made from any candidate or committee, either orally or in writing.
So the concern is with the orally or writing portion of that?
From any candidate or committee. Because as I recall, in some of the behest payments are saying the mayor may not solicit, right? But he may not solicit from a contractor. But if the definition of solicit means he's got to be requesting the contribution from any candidate or committee, it just seems inconsistent with what you're saying in other sections of the code. That's all I'm saying.
Okay, we can evaluate that. I'm sorry, I don't have a good answer for you now.
Right.
Commissioner Chu. Oh, I'm sorry. Commissioner Lee,
Thank you, Mr. Chair. I just have one clarification question. So you had mentioned that you have removed the asset payment ban, so we're not going to be discussing that tonight?
Well, so what was the behested payment ban was in the campaign finance code. We removed that from that section so that it doesn't prohibit any for-profit or not-for-profit business from giving a behest, but we have moved that provision to the conflict of interest code so that any elective official or member of a board or commission can't solicit anything of value from someone who has business in front of them unless one of the exception applies. So it's been moved to the conflict of interest section to save any potential constitutional challenges because it's a restriction on a public official, which are subject to a sort of lesser standard of scrutiny as far as legal analysis goes. It also is putting the impetus on a smaller class of persons to have to follow the rule and understand its constraints. Someone that we train and we inform and we provide advice and manuals more often. So hopefully that, and again, with the exceptions, hopefully that limits the effect on those charitable organizations and nonprofits that are doing their good works. But it is not totally removed, I would not say no.
Commissioner Chu.
So, Mr. President, I have a few more questions, but
Sure.
we'll get into the nitty-gritty of the actual ordinance. So on page 12, line 7, first sentence, no city contractor who is party to or is seeking a contract. Does this contemplate current contractors? Current city contractors?
Yeah, who is party to? Sure.
Who is party to, so current contractors as well as prospective contractors?
Correct.
Okay. Just wanted to clarify that. Because the way that the law currently reads is that it only applies to prospective contractors, is that right?
No, it applies to both. Yep.
Okay. Next is the private right of action.
Yes.
So I believe it was the last meeting, or maybe the meeting before, there was a proposal to change the probable cause review process here at the staff level at the commission. So I think that this provision here presumes the existing process, because if the resident may not commence an action under the subsection if the commission has issued a finding of probable cause. But if there has been the process and no finding of probable cause has been issued, that is currently not public.
Yeah, so the likely effect of this is that, I mean, so the finding of probable cause would be public, but it's not likely to occur that, it's not likely that within the 60 days allotted here that staff would be able to act on that matter.
Okay, so do you envision then that if there's a private right of action that, and so the private right of action proceeds and city attorney, DA have not pursued action, but the Ethics Commission is currently investigating but has not yet made a determination of probable cause, that the two actions would proceed in parallel?
I think that would have to be the case, yes. If we haven't issued that report, they are going to be able to proceed.
Okay.
And let me clarify for 1 second, maybe on that point. Deputy Director, do we need any clarification on that point?
Oh, no, sorry. No, we were disagreeing. We were agreeing. We had talked about it earlier today, actually, about the possibility of a concurrent enforcement action because of the quick timetable here. And we agreed that there would have to be an opportunity for concurrent enforcement action by the commission and the citizen plaintiff.
Commissioner Kopp.
I want to follow Commissioner Chu's questions on those issues. Page 12, line 7, the prohibition on contributing. Maybe I'm missing it. What's the time within which the series of contracts must occur?
So on the bottom of page 12, line 25, the termination of negotiations for such contracts are 12 months from the date the contract is approved. So the commencement of, or excuse me,
Well,
the term.
what's the series? Is it a series over 2 years, 1 year, or separate contracts, or is it one contract divided into segments?
It's each individual contract.
Pardon me?
Each individual contract.
Over what period of time? A year? 2 years?
So each individual contract would be subject to this so that if the termination of negotiations for one contract ended, but there was another contract in negotiations that was then approved, it would apply for the entire 12 months after the fact. So it's each individual contract. I'm not sure I'm understanding the question.
So it's 12 months.
It's 12 months, yes, if approved, yeah.
Where's that set forth?
Page 13, line 1.
Okay, thank you. Let me go to the private right of action. Where does this 50% provision come from? Is that state law and a key TAM action?
It's the 50% is in the PRA. It is also taken directly. This is mimicking the LA provision, but it is also in the PRA. Sorry, I don't have the specific provision offhand, but it also is in the PRA.
That seems a lot. But that's subject to discretion of the trial court, correct?
I honestly, I believe it says shall receive 50%, so I'm not sure what discretion they have.
So it's...
The trial court would have discretion the trial court, like in any case, would have discretion to assess the penalty, but once the penalty has been assessed, there's no discretion. 50% goes to the plaintiff, 50% goes to the government.
Is that state law, too?
That's state law, too.
All right. Thank you.
Commissioner Chu.
Sorry to piecemeal you like this. What has been the experience of Los Angeles with this provision?
So it's been used very infrequently, in our understanding and speaking with them, 2 to 3 times since it's been sort of on the books. Again, it hasn't been used a lot. There was some, I don't, worry is probably not the correct word, but there was some concern, I guess worry is the only word I can think of at the time, that this provision could be used to submit frivolous actions or just plainly overburden the courts with these actions, particularly as it relates to sort of administrative items, such as late filings,
Technical violations.
Yes,
right.
technical violations, thank you.
Okay. So I'd like to hold some questions on the, until we've heard public comment.
Oh, sure,
On the,
yeah. That's fine.
on the section 3.207 as well as the, anything of value.
Very well, that won't be a problem. Commissioners have any other questions or comments before we go to public comment?
Actually, yes.
Yes,
do.
Commissioner
So
Chair.
I wanted to thank the members of the public who came to the interested persons meeting that I attended last week. It was very helpful to me, and I think it's really critical and important to hear your voices and to help me, at least, and also this commission, make the best decisions that we can for the people of San Francisco to have a responsible and accountable government. So thank you all for coming today, and I really look forward to hearing your views on what we're discussing in this proposed ordinance.
I'd like to endorse Commissioner Chu's thanks to those who came to the interested persons meetings. Those are essential for us to go ahead and carry out our duties, to know what the analysis generally of the public is. And in the last few meetings, what I understand, it was very incisive and very instructive for the staff and for all of us. So with that, Commissioners, if there are no further comments or questions, we'll go to public comment.
Good evening. I'm Jennifer Fieber. I'm with the San Francisco Tenants Union. We operate a clinic for tenants with housing problems. We're open 6 days a week. We have an operating budget of $200,000 a year. We also file ethics forms because we do endorsements in slate mail around ballot measures and candidates that have to do with tenant issues. So I'm really concerned about this provision over the right of private citizens to have a civil action over, technical filing requirements. The election rules are really complicated and they keep changing, and I rely on the advice of well-trained staff in the Department of Ethics and also this commission to clear up ambiguities. You guys really are the experts on this stuff, and you're the people I want to turn to for knowledge and decisions on this stuff. So I am very worried about frivolous lawsuits by our enemies who want to sue us out of existence for political reasons. Let me give you a couple of examples. A complaint was filed against us for our wording and a disclaimer. I'm pretty sure that it was an angry Airbnb host when we were trying to get Proposition F passed. I was able to discuss the matter with department staff, and they reached the conclusion that no violation had occurred. So would the new rules allow Airbnb to pull us into a lawsuit because the department didn't take an action? Additionally, when our former staff member Ted Gullickson died 2 years ago in October, he was the only employee at the time, so he took care of all the paperwork. Our board and our volunteers were unfamiliar with the filing requirements, so it was not until a year and a half later that we received a letter that we had missed a deadline. We technically did violate the rules, but we were able to ask for a reduction or elimination of the fines because we could explain that Ted died in the middle of an election cycle. The department was very sympathetic to the situation, and they reduced our fines. I would much rather have a knowledgeable, neutral party making this decision than be facing off against a real estate lawyer in a lawsuit. Even if we won, it would be staff time and costs that we can't afford. I think that tenants in the town would really suffer if we didn't exist, but I don't want to have to make the choice of getting out of the business of making endorsements and running our services. I think that this legislation is well-intentioned, but I just worry about civil action over paperwork errors that will lead to marginalized voices being suppressed, such as tiny Democratic clubs. The goal of this is to level the playing field for those without deep pockets, but I just ask you to think about, the ramifications and who has the money to pursue these kind of charges. Thanks.
Question, Mr.
Yes,
Chairman.
Commissioner Kopp.
Yeah. You said your budget is $200,000?
Mm-hmm.
What amount, if anything, is received from the city and county?
We don't get any. It's all from member dues.
It's all from?
Membership dues, we don't get any city money. So,
And do you provide services directly to low-income or no-income
absolutely,
clients?
yeah.
All right, thank you.
Could I follow through on, I just want to ask, you raised an important point, I want to pursue it with our staff. Do we have any information as to whether or not in Los Angeles or any other place where they have this provision for a private right of action, that it has been used politically in order to intimidate particular groups or causes, such as what we've just heard about? Because you can see that being an instrument of some damage to some good things that might occur. Do we have any knowledge of that?
So LA relayed that it hasn't been used for that. They did raise that the specter of that, but no, not any actual on-point data or anything pointing to that being the issue. We did speak with others, and I'll have to speak anecdotally for them, so take that for what it's worth. But we did hear that the FPPC did initially the PRA and the FPPC, when they initially had this in their bill, that it was used at least for a time. It was raised that this was being abused, but they apparently made some amendments to the language that reduced that issue. Again, I'm sorry, I'm speaking anecdotally, so I don't have a great time frame for when that occurred, but that otherwise there was no specific examples of it being abused in the campaign finance ethics law context.
Okay. Thank you, Mr. Conrad.
Thank you. I'm Ian Lewis with the Hotel and Restaurant Workers, and I want to echo the comments of the Tenants Union on that subject. We are as big a proponent as there is for reining in corporate influence in politics. And I understand you have a very tricky balance to strike here. Doing that work, but also encouraging and clearing all the many barriers there are to public participation in their government. The ethics laws are complex, and they're getting even more complex quite rapidly in recent years. And whether or not there are actual examples in LA, not only the complexity, but certainly now adding in the possibility of ambulance chasing lawyers being incentivized to pursue, to support people who want to take retribution against groups by finding technical violations and suing them, has a chilling effect. That would have an absolute chilling effect on people's participation and organizations' participation, particularly small ones. Those are the groups we want to encourage participating in politics. So rather than go in that direction and further privatize the enforcement of these laws, I really encourage you to look at reinforcing the good stuff that you already have. In my experience, they are more than fair and more than thorough in enforcing the laws. If you need more funding for that, that's a great discussion to have with the Board of Supervisors and with the Mayor. But going in the direction of privatizing the enforcement actually worsens the problem that I think we'd like to see fixed. Thank you.
Good evening, Elena Schmidt with Friends of Ethics. I know that you're going to hear a lot of details tonight from the various participants. I want first to kind of set a context, since we've been around for a while and dealing with this issue, and just start out by saying that the staff proposal in front of you was not created out of whole cloth, that we've been dealing with this issue for a long time, issue being the pay-to-play aspect of San Francisco's political culture. Over the months that you've been looking at it, this has been referred to as the Prop J revised. And a bit of history on that. Prop J was passed in the year 2000 with a margin of 83%. It lasted for 3 years until Prop E was put on the ballot, asking the voters to amend some conflict of interest language, and it had the undisclosed effect of deleting the Prop J language. So it was only in effect for 3 years. The substance of the original Prop J has worked its way back for your approval, and I certainly hope you move forward with it. Tonight's potential action is built on the recent history of reports, multiple calls for the Ethics Commission to stop San Francisco's pay-to-play culture, and the detailed analysis from 3 civil grand jury reports, a Harvey Rose report, much assistance and many conversations with election experts, and of course the various drafts that your staff has done over the months. Bob Stern, a co-author of the state's Political Reform Act, came and spoke about this effort at a commission meeting last year. Various versions of the Friends of Ethics recommendations have been reviewed by Ann Revelle, the past chair of the Federal Elections Commission. Represent Us has worked with us throughout the couple of years. Common Cause has worked with us. We've reached out to the Brennan Center for Justice, which is part of the New York University. MapLight has recently joined the action. They're a data analysis nonprofit, which since 2005 has investigated the dark money throughout the nation. In 2016, MapLight worked with the California Secretary of State in their analysis of the money behind the 17 propositions that were on the ballot that year. Campaign for Law Center, a Washington, D.C. nonpartisan group, which has worked for 15 years for the information. I'll note that there are 3 reports of the civil grand jury. 2011 report dealt with the internal workings of the commission. The 13-14 grand jury report was the one I was the foreperson of, and we came out with 25 recommendations about the Ethics Commission. And the 14-15 grand jury report followed up on the 13-14 report about the whistleblower. It's taken years to get where you are. You've been presented with an impressive and comprehensive package that goes a long way towards providing accountability and transparency for the political dollars. Thank you.
Thank you.
Question?
Yes, Commissioner
Ms.
Kopp.
Schmidt, do you have an estimate of what percentage, approximately, of Proposition J is contained in the proposal before us as item number 4?
I do not have one. I would guess that it is less than 50%, but it is some of the key provisions. But I believe that there's someone in the audience who might be able to give you an answer later.
Thank you.
Good evening, Commissioners and staff. Torrin Lewis on behalf of Alliance for Justice. Nice to see you again. I sincerely appreciate you taking the time to hear public comment. And on that note, I have to say, first of all, thanks to commissioners and staff. Sincerely, I think throughout my interaction with you all, we've really seen a strong attempt to incorporate public comment and public concerns. And to that effect, I'd like to talk about Section 3.207, the new behests restriction in the Conflicts Code. First, I'd like to say, again, we think this is a dramatic improvement from our perspective, representing nonprofit organizations. On the prior version, both the emphasis of liability on the public official instead of anyone, be it a board member or staff of a nonprofit organization. And likewise, we commend the exceptions both for public appeals and emergencies. So it can't be overstated how different these elements are from the prior version. That being said, we would respectfully caution that As it's written, 3.207 is still a novel interpretation, under California law at least, of the concept of a conflict of interest, in that it expands the notion of economic interest to include solicitations of payments to third parties. And what's more, of course, as an organization that represents nonprofit organizations, our concern, again, is still that in so doing, this legislation might inadvertently chill legitimate and also commonplace nonprofit fundraising practices with the help of public officials. Of course, the exception very clearly exempts public appeals in that sense. However, a lot of, again, commonplace, perfectly legal nonprofit fundraising today takes place through one-on-one solicitations, or at least that's something that's currently permitted. And we feel strongly that it's permitted because there's a fundamental difference between soliciting funds for a third-party, nonprofit, charitable organization and soliciting funds for one's campaign bank account, ballot measure campaign, and of course soliciting gifts or unlawful bribes. So we would respectfully ask that another look be given to 3.207 for that reason.
Can I just ask you,
Certainly.
and after all of the work we've done in order to accommodate nonprofits, for you and other nonprofits to come in and still have this complaint really galls me. I see it as totally disingenuous. What we're trying to do here is we are trying and control corruption in San Francisco. What we have done is we have totally exempted any possibility of the nonprofits suffering any kind of jeopardy, the employees of the nonprofits suffering any kind of jeopardy, or the nonprofits have to worry about filing or anything else. What this solicitation has to do with a public official who is in a position to favor someone, to do a favor to someone, soliciting that person to give a donation to something that public official likes in order to get a quid pro quo for that public official to do something for them. It is a condemnation of bribery. It is a condemnation totally of corruption. So for you to stand there and say somehow that this limits nonprofits in some way from doing what they're doing, to me, defies any kind of understanding. We have done away with all of that. We have shrunk that down to its pure core here. And essentially, for nonprofits to come in and say that they are in favor of a public official or a politician being able to put the arm on someone to whom they can do a favor, if that individual will give something to somebody, to anybody, whether it's a nonprofit or anyone else, that somehow there's a problem with that? Ethically, there's a problem with that? That is pure corruption. And if you are saying that somehow that should not be done because it harms nonprofits, that is totally bogus. In terms of all of the stuff that we've heard so far, at the last meeting, we went with the staff into a lot of work in order to make sure that the nonprofits do not have any problem. And to see a lineup now of the same cast of characters, if they're going to give the kind of spiel that you did, that's very disappointing.
I have a question.
You mind if I respond, Commissioner?
Go ahead.
Sure. So, Chairman Keene, I want to be very clear. First off, we are not tone deaf to what it is that the Commission and staff are trying to achieve. We, too, have read the newspapers. I myself am fairly familiar with the area of law, and so to be very specific, what we are saying is that is not at all an endorsement of quid pro quo corruption or even the appearance thereof, but rather that state law, for example, in the creation of the category of behested payments versus campaign contributions, very purposefully drew a distinction. The FPPC, prior to 1997, when the legislature took action on this matter, actually was equivocating, so to speak, between campaign contributions and behested payments. The legislature stepped in and actually amended the Political Reform Act to create a separate category of payments that were not subject to, say, the gift limits or campaign finance restrictions, because they recognized them to be fundamentally different in pursuit of charity. And so, furthermore, I would also observe that there are many avenues of the law, aside from just the Political Reform Act and Government Code Section 1090, the common law conflict of interests doctrine, federal law, the honest services fraud provisions, bribery provisions, that also can be mustered, to fight this same corruption and appearance of corruption. So we're not at all pro-corruption. We're simply drawing a very fine distinction between behested payments, as they've been recognized as a separate category under state law, and saying that this would be a departure from that. And we very much respect that. If you choose to make a departure, that's of course your right, and we will respect that. But we would urge very respectfully that there is a difference here, because not all payments made to charities by people with interest before the state are necessarily evidence of corruption. And so,
nor does this legislation say that. It says only if you have a public official or someone who is a public officer who gets an individual to make that payment, and then and that individual making that payment to someone that public official is going to pay off with some sort of favor. That's the only thing that we're targeting here. So to say that you are not in favor of corruption, when essentially what you're doing is you're coming in, you and the others are coming in and saying, no, we shouldn't do this, I find totally insupportable.
Question.
Commissioner Cobb.
Tell me again the name of your entity.
Alliance for Justice.
What is it?
Alliance for Justice.
Alliance for Justice. And what's its purpose or mission?
So we're an association of over 120 nonprofits nationwide. I specifically work for our Boulder Advocacy Initiative, whose role is to train and educate nonprofits on advocacy.
All right.
So
do
lobbying,
you
campaigns.
Obtain any money from the City and County of San Francisco annual budget?
Not to my knowledge.
All right. And I infer you don't render direct services to low-income or no-income people.
No, sir. We provide training to nonprofit organizations.
Thank you.
Can I ask you?
Commissioner Rennie.
Certainly. I noticed in the letter that you submitted and listed the organizations that go on for pages, including the opera and the ballet. In what way is the ballet or the opera going to be injured by this legislation?
So I don't specifically recall mentioning the ballet or opera, but our concern is generally for nonprofits as a class of organizations, and simply that as state law currently exists, asking a government official asking a third party, asking for a donation to a charitable third party is legal, is not a violation of the Political Reform Act. It's not bribery under state bribery laws. And our argument is that it's that way for a reason, because there's a fundamental difference between me asking as a city or county official for someone to donate to my campaign account so I can be reelected versus me asking for someone to donate money to a school or a food bank.
In return for getting some benefit from that city official. How is it different?
Well, I think the fundamental difference is the unethical part would appear to be the exchange the quid pro quo exchange,
Right.
not the request for a charitable solicitation itself. So, in essence, we feel the legislation almost characterizes the request itself as a per se evidence of corruption when state law does not.
If that official and the individual to whom he's making the request has something that the official can give him as a benefit, that is a quid pro quo. I mean,
For example, Section 84308 of the Government Code that restricts pay-to-play in a similar manner with campaign contributions requires there to be some kind of financial interest on the part of the intervening official. And so we think there's a distinction here where if I, as an official, am asking for a charitable donation to an organization I don't control, I cannot profit from, that by definition is not an economic interest of the official. There might be, if there is a quid pro quo, that might be some other kind of ethical misconduct involved because of that arrangement, but the solicitation on behalf of a third-party charity itself is not, should not be considered as an economic benefit accruing to the public official from our perspective.
Commissioner Lee.
I'm sorry.
The San Francisco Ballet submitted its own letter.
pardon me?
San Francisco Ballet submitted its own
Yeah.
letter, so.
No, it isn't. I don't think they submitted their own. That was in your attachment. I think that, but I think that's part of the attachment. Oh, is it separate?
My question is, what if a public official asks
I'm sorry, is
lawyers?
her, I can't hear you very well. Is your microphone on? Is it on, Pat?
Maybe.
You may want to just pull it a little closer, Commissioner.
See if that helps.
Softly. Yeah. What if a public official asks somebody to, or just suggest to somebody, one of your members, is putting together a walkathon to raise money to support children's services? That was, the program was being cut by the federal government. Would that be a quid pro quo to you?
So I have to stress that I am not, a former federal prosecutor or district attorney, so I'm not intimately familiar with public corruption law writ large. But I can tell you that from my familiarity with the Political Reform Act, the only thing that is required under the Political Reform Act is that behested payments over a certain monetary threshold be disclosed, and that distinction was intentionally drawn by the state legislature in response to FPPC regulations and interpretations to the contrary. And so my point was simply to draw that distinction that, so in that case, asking an official asking someone for a donation to the walkathon, if the payment totaled more than $5,000, that's something that would need to be reported. Now, if the official asked for a donation to the walkathon in exchange for favors, again, I'm not an expert on city or state or federal corruption laws, but my suspicion would be that that might run afoul of other provisions because of the quid pro quo itself.
Commissioner Chu.
Yeah, so I think what I'm hearing here is concern, as you've expressed it, on the part of nonprofits for the impact that this section is going to have on your ability to fundraise, which is very critical to being able to have a complete budget in order to be able to provide services. And I think that, Chair Keen, that what in the public interested persons meetings that we had last week, I have not heard any nonprofit organization express anything other than support for accountable government and the efforts at curbing corruption that this ordinance is intended to do. But what I'm also hearing is a deep concern on their part, and I see more leaders in line to make public comment, and I think that it's incumbent upon us, if we hear that they are having concerns because we're not seeing the same language and interpreting it the same way, I think it's important for us to listen and figure out, well, what is it that we are missing or staff is missing in terms of crafting something that can address their concerns, and at the same time, pushing forward the important interests of, curbing corruption and the appearance of corruption.
Commissioner, I completely agree with you that we should hear their concerns. We've been hearing their concerns now on this matter over a number of issues, a number of meetings, and we've refined this down in terms of meeting their concerns on everything. And we still have essentially the same group of nonprofit people at this point saying it is okay with us, even first of all, giving a disclaimer, we're against corruption and we thank you for engaging in this anti-corruption stuff, but it's okay for us to have a corrupt public official put the arm on some individual who is seeking a favor in order to get that individual to give something, if it happens to be us, the nonprofit who are the recipients of it. Now, that is corruption, whether or not you're giving the money to Al Capone or you're giving the money to crippled children. It's the same thing if you have the person who's giving the money getting some sort of benefit from the public official who is leaning on them to give it. And that's all this does. And you are coming in, you, the representatives of nonprofits, should be ashamed of yourselves. You're coming in and you're saying that's okay. We want to continue to do that because we may get some of that corrupt gift. And I think that's really a shame.
Keene,
yes,
if
Commissioner.
I may, I don't think that any, and I don't want to speak for any of the nonprofits, but I don't think that what I heard this gentleman here say was that a payment in and of itself is per se evidence of corruption. But I think that that's the underlying assumption in your statement just now. That simply by making a payment, so the mayor says, Judge Kopp, I would really like you to contribute to a nonprofit because I think this organization does great work and there's a contribution that's made. That in and of itself, I don't think is problematic. It is problematic if I as the mayor then say, all right, your contract, your land use matter, that's going to sail through with a green light. No.
Well, but you're leaving something out. You're failing to say that the mayor is saying Judge Kopp, and Judge Kopp happens to be someone who has a permit pending for a 200-story building. I want you to give something to this nonprofit. Will you do that? And Judge Kopp is going to tell the mayor, no, I'm not going to do that. Even though he's someone who's in a position and needs a favor, that's the only situation where this applies. If it's just asking Judge Kopp to give to somebody, there's no problem with that. But if Judge Kopp is going to be the potential beneficiary of something that the mayor can do or is seeking some favor from the mayor, then the mayor should not be able to ask him to make a contribution to anybody.
So I just want to point everyone to the specific language quick that we're talking about. It's on page 58 of the material or page 26 of the ordinance.
What section?
It's section 3.207, sub 4. And if you look at lines 3 and 4, you'll see that it's only, so it's no city elective officer or member of a board or commission or by means of an agent may request that a person give anything of value, in the key portion, the person who is the subject of the request has a matter pending before the official, his or her agency, or the official has final approval authority. So they have to have a matter pending before you. And I think it's, as Torrin pointed out to 84308, has the same sort of logic. Now, yes, there is some sort of financial thing with $250, but we're talking about potentially asking for thousands of dollars. So I think other courts have addressed, circuit courts and the Supreme Court have said that, and analyzed this in particularly the context of the judicial realm, that these sort of expenditures have value. They might not be a direct financial value, but they have a value to say that there is an influence that's given, that's from a contribution that's made to a third party, if it's $10,000, if it's $1,000. You know, I just think that's a little difficult to believe, and I think the courts have found it difficult to believe that there's no benefit or no thought process by the elective or public official that if they're requesting something, particularly for someone who has something in front of them, pending in front of them, or who had something in front of them recently, that them soliciting something in the form of even a third-party give does not inure some benefit to that public official.
I got another question now.
Let's hear, excuse me,
So sorry,
Commissioner Connors, we
Commissioners.
can just,
One more point I'd like to make is the quid pro quo corruption that Torrin was speaking about, where he was envisioning a world where existing law would prevent the quid pro quo corruption of the behest and then to the third party. That's not necessarily true because current law requires a financial interest on the part of the elected official in the third party. So if the elected official isn't related in any way to the third party, if they aren't a board member or taking a salary from the nonprofit, there's no quid pro quo there under existing law. This is a fix to existing law to prevent the mayor from being able to ask a contractor to make a behested payment to a third party in which the mayor doesn't have a personal financial interest.
Commissioner Lee.
Thank you, Mr. Chair. I would personally prefer to hear all the public comments first before we have a discussion. But nevertheless, I do want to have a question through the chair. Under this language on the third-party payment, we all know the Golden State Warriors have a major issue pending before the city. What if a public official went to a game, saw a player, and asked this player to speak to a group of at-risk youths? Does that count as anything of value, which under this, I interpret it as anything of value? And that also precludes this person from doing so because the lawyer has a matter before the city, even though it's going to take 3-4 years. So does that mean for the next 3-4 years we're not going to see anybody from affiliated with the Warriors to attend events that benefit youth, speak to the youth, speak about, healthy living or whatever it is? That's my.
The answer to that is no. It does not preclude the Warriors from doing whatever it is that the Warriors want. What it precludes the official, the public official, the elected official, who's in a position to do a favor for the Warriors from asking them to do it. But if the Warriors, if the public official does ask, the public official is violating this. If the Warriors then decide that they want to go ahead and do what the public official asked for, they can do it under the language that we have. That doesn't preclude them from doing anything. It's meant to preclude the elected official who's in a position to do a favor for someone from asking that person to do something. That's what this precludes. Makes it a conflict of interest for the politician or official who has the power to grant something to someone to say to that person, hey, by the way, I'd like you to do this. That's what it precludes.
Yeah, and so just let me clarify one more time. So again, we're back on page 26 of the ordinance, page 58 of the packet overall here, lines 3 and 4, and then So again, it's only if the person that's the subject of the request has a matter pending. So as you say, the Golden State Warriors in that scenario. But again, these solicitations could also be made if it was a public request, if it was at a meeting or an event in which 20 or more persons are in attendance. They could ask if the board of director of the Golden State Warriors are there. They would be exempted under that thing. They could ask at that event. We're just closing the gap on those sort of smaller one-on-one, smaller group, where there's those smaller bodies where those in private, behind closed doors solicitation. So we've narrowed it to a class of. First of all, you have to have a matter pending before that official. And we've carved out these larger items that we heard for exemptions that we heard previously, like the fundraising galas and a public request of the mayor. The mayor gets on TV and makes a pronouncement for you to give to some effort, so on and so forth. So I think we have pretty narrowly tailored down the circumstances and scenarios that could be construed as inhibiting their fundraising ability of those nonprofits.
Peter.
Commissioner Kopp.
A lesser question to staff. What is it? Subsection A, 5B. The solicitation is made at an event where 20 or more persons are in attendance. I'm curious as to the origin of 20.
That came from me.
Huh?
That came from me.
Yeah.
Just because
Why
one of the
20? Why not 10?
Well, it could be 10.
Huh?
It could be 10. It could be 5 if you want. The main thing was I was attempting to meet the objections of a number of the nonprofit groups who said, well, we have someone at a coffee, or we have someone at a group,
right,
and
okay.
they make this, and they say, well, why don't you give to something, give to this group, to our group,
right.
And we've made it. We're saying we can't do that. So
I think you gave away too much. Okay.
All right. Well, I think 20 is okay. Commissioner Kopp would make it 5, but.
Thank you.
Yeah,
Well, thank you very much.
Note that in the minutes, please. 10 years from now, somebody can exhume that.
Yeah, absolutely.
Good evening, Commissioners. Debbie Lerman from the San Francisco Human Services Network. Again, we agree with most of what's in this legislation, and we appreciate the proposal no longer bans behested payments and no longer imposes potential liability on nonprofits. However, it has a similar effect on fundraising by prohibiting solicitations, with limited exceptions once you've counted heads in the room. In fact, it expands the impact even more than the previous behested contributions ban. It includes non-material behests like payments, and, favors, and services. There is still no minimum threshold whatsoever on the value, despite the lack of corrupting influence in small donations. It applies not only to elected officials, but expands it to boards and commissions. And it includes any matter that comes before those bodies, not just contracts and land use decisions. So it creates an even larger group of off-limit potential donors. We have continuing concerns about the prohibitions on the ability of public officials to help nonprofits raise funds. We're also concerned it would restrict other forms of collaboration between nonprofits and government. The city has dozens of public-private partnerships to raise funds for important city services, such as the $30 million Heading Home initiative to fight homelessness, the expansion of navigation centers, the Zuckerberg General Hospital, affordable housing, parks, all the funds that are listed on the city's Give to SF website. This would cut out a broad swath of potential donors that could not be solicited for funds, such as the Giants, the Examiner, nonprofits and their boards, the arts community, tech companies, etc. It's also vague in its language around matters that come before a body. It's very broad in its scope to the point where we are unable, with so little time to review it, to ascertain all the potential unforeseen consequences or evaluate the benefits of those donations versus the actual potential for corruption. In fact, the only relevant data we have on record is the $5,000 behest reporting requirement. So we have no idea how much this proposal would impact anything. And we continue to believe that the better approach is stronger transparency and disclosure. I also want to touch extremely briefly on 3 other points that I have yet to hear the Commission respond to. These have been in our written comments. What is the justification for including volunteer members of nonprofit boards who have no financial stake whatsoever in any of these decisions? Secondly, there's a provision on page 13 around notification by prospective parties to contracts, which would violate confidentiality provisions and undermine our contracting and sealed bid processes. And the repeated recusal provisions we have referred to before, because it would unfairly scrutinize nonprofit representatives who recuse themselves appropriately when they're looking at their own employers' contracts.
Question.
Yes, sir.
Commissioner Cobb.
Ms. Lerman, you and I met with Mr. Cohn and Mr. Welch,
Yes,
a couple of weeks ago or last week.
Yes.
I have, and you gave me your card, San Francisco Human Services Network.
Yes.
Do you furnish any service directly to a low-income or no-income person?
We are an association of San Francisco Health and
So
Human Services
the answer to that
Network,
question is no, you do not.
The answer is no. I do not.
And second question, do you receive any funds of the city and
No.
county? The answer to
No, but our
that is no.
members do.
Okay, thank you.
Thank you.
May I ask you
Commissioner Rennie.
a question? You have said this would ban trying to go to the Giants to raise money. How does it ban your going to the Giants for money?
They are potentially seeking a land use decision for major development. They may.
You aren't a public official. When you go to
No. It would ban public officials asking them to participate in public-private partnerships. For example, the Heading Home, the $30 million Heading Home initiative included solicitations to and donations from the Giants, from Google, from Salesforce, from the Benioffs of the Twitter.
And these were all
company. So
public communications raising money. And
that's not clear that
that's
those may
exempted.
have been one-on-one solicitations.
Those are all exempt. That's the language we put in order to meet your objections of if it's done publicly, if it's a public communication.
It's not clear the solicitation, the individual solicitation asking the Benioffs to contribute to Heading
Individual,
Home.
no.
Well, we
it
don't know
isn't.
that there is a long list of donors. to
If
Heading
it's
Home-
individual, if the mayor
Yes,
is
exactly.
in a position to help the Benioffs and therefore can say to the Benioffs, you give to some particular entity, be it a nonprofit or Commissioner Kopp's favorite charity or whatever,
Korean War Memorial.
Korean War Memorial,
Yeah.
that's the mayor putting pressure on someone who is seeking a favor. And you can't, that's what we're doing. So the examples that you're giving are simply false examples.
I'm sorry, Commissioner. Some of these were done, I'm sure, by individual solicitations with public officials asking wealthy donors to contribute to legitimate city causes, as it does with many of its public-private partnerships. The mayor's office even has staff whose very job is to put together these types of partnerships. And that is often the way these kinds of initiatives
And those would be public
happen.
communications if the mayor is doing it, because those would be public acts on the part of a public official. What we're talking about here is something where it's just a one-on-one type situation of a particular official who has power saying to someone whom they can do a favor to give to a particular individual That's what we're saying shouldn't be done.
And we certainly agree that a public official should not say to an individual, give or we will or will not grant the favor that you're seeking.
He's never going to be
He's
that
never going to say
specific.
that.
That
He's never.
is,
he's
but that
never-
is the very concern, that every solicitation is not a request for a quid pro quo, and there are many legitimate city public-private partnerships, in fact, dozens of them, where solicitations happen
And they
all the
aren't
time.
covered by any provision in this bill.
They are a public
not.
official requesting a donation by somebody who frequently may have a contract or a land use decision or some other matter pending before a city body. And that is the plain language of the ordinance. The ordinance does not require any intent of quid pro quo. It merely makes those types of solicitations illegal.
This does not affect anything except corrupt conduct by public officials. And you, Ms. Lerner, as someone who is a representative of all of the nonprofits of San Francisco, you give a bad name to nonprofits by coming in and saying that somehow this type of anti-corruption measure should not be enacted.
I respectfully disagree.
I have one more question.
Yes, Commissioner Cobb.
Two other people were with you in my office, and one of them is Peter Cohn, who isn't here tonight, is he? Oh, he is here. Oh, I didn't recognize you. Fine. Are you going to testify? Okay. I'll save it. Thank you.
Thank you. Anything else?
Yeah, none of these people are on it. So, asker, payer.
Good evening. My name is Ben Becker. I'm the co-chair of the San Francisco Bernie-crats, although I'm here on a personal capacity tonight because I haven't asked our group to vote on any endorsements or anything of that sort.
What's the organization?
The San Francisco Bernie-crats. It's a nonprofit group, a club here in the city that was formed after the Bernie Sanders presidential campaign last summer.
All right.
I wanted to come and speak to the potential striking of Section 1.163.5, distribution of campaign advertisements containing false endorsements. It's my understanding that last year another club, political club in the city, the RFK Democratic Club, produced a number of endorsements for candidates and campaigns of all sorts. And the Kennedy family had to come out after them and request that they change their name.
Oh, yeah, I remember that.
Yes.
Yeah.
In addition, regarding the soda tax ballot measure, the folks who were against the tax used Bernie Sanders' image and a quote in advertisements last year saying that Bernie was against soda taxes, although he had not come out against this specific measure. So I wanted to ask that this section not be struck. I understand the point that it may not be constitutional. That may be true. I think we should allow courts to make that decision, and I think we shouldn't preemptively make that decision ourselves. At the least, it would provide.
Excuse me, may I, Mr. Chairman? Don't take it off your time. I thought you said 1.165.
1.163.5. It's page 18.
All right, that makes sense, and that appears to be deleted, and you believe it should not be deleted.
I would request that you don't.
And thank you.
Go ahead and continue.
Please continue.
Thank you. So I was simply going to say that I understand, that this may be something that will be seen in court in the future, but simply retaining it as it is makes a statement from the city and county of San Francisco about where we stand on using false endorsements, and it also provides some sort of a financial barrier to groups that might try to misuse somebody's name or their endorsement. I think that's about all I have to say. I don't have a statement on the behested payments at this time because I don't understand it well. I do appreciate the idea of what you're trying to do. So I hope that you and the nonprofits and everybody can come to some sort of a resolution. Thank you very much.
May I follow up now on that question?
Sure, yeah.
What's the reason for the deletion? Probable unconstitutionality?
Again, so the Ninth Circuit has spoken on this in the context of U.S. v. Alvarez, which was not in the campaign finance context, but at least two other circuit courts using that case as the sort of primary case law on the matter informed us that although we may not like this speech, false speech that is, that it is, however, constitutionally protected. So I agree with the sentiments, but unfortunately.
Yeah, okay. Thank you.
Go Bernie.
Yeah. Go Bernie.
Hello, I'm Paul Melbestad. I served on the Ethics Commission from 1995 to 2003, which was the period when, for the first time, the Commission exercised its power to put a measure on the ballot, Proposition O. And I'm here to speak in support of the Friends of Ethics proposal to include a prohibition on bundling of contributions and also a prohibition on gifts of travel expenses by those who, in the process, having pending applications for city contracts and pending applications for land use approvals. And I am very familiar with the land use approval process because prior to serving on the Ethics Commission, I served for 4 years on the Board of Permit Appeals. I want to welcome the two new commissioners and thank you for your service and suggest to you you're fortunate to be able to serve as I was with such distinguished individuals as the previously serving commissioners. As a citizen of San Francisco, I'm very grateful that we have ethics commissioners with 30 years or more experience in the local political and governmental process who know how the games are played, and don't let any political professional lead you to believe that being smart means you're being biased. It's not. I would submit to you that you should include the ban on gifts of travel and bundling of contributions because it makes no sense that we prohibit making political contributions more than $500 per person because we believe that contributions much larger than that would tend to influence an official's decisions. It makes no sense then to allow those seeking land use approvals and contracts with the city to make a gift of $5,000, $10,000, $20,000 or more to pay for a trip. Now, if a trip by a government official is for a official purpose, such as to see how some type of public transit program is operating in another city or meeting with officials of other cities or other countries, if it's for official purpose, then the city should pay for it. And it's worth it because that way the citizens know that the decision is based on solid public policy reasons and not based on who paid for the trip. But it's just common sense and it's just human nature. If somebody's paid for you to take a trip that would cost you $15,000 to $25,000, you're at least going to give that person access. So I hope you will include in the staff proposal, or you ask the staff to add the prohibition on gifts of travel expenses by those seeking contracts and land use approvals, and also prohibiting bundling of contributions. Thank you.
Yes, Kyle has Commissioner Kopp, then Kyle, I think you.
Same question I asked Ms. Schmidt. Have you formed an estimate of how much of Proposition J is in the proposal before us?
No, I haven't, and
okay.
I would embarrass myself if I tried to do that.
That's all right.
Kyle.
Yeah, so I just want to make just a couple comments. So regarding the travel restriction, state law has a provision on sort of exempting travel from the general gift ban. We do, however, in our local law in 3.216, we do have something that says you cannot accept anything from a restricted source, which is effectively anyone, again, doing business in front of you. And there's a very de minimis limit of $25. So there is something in there that would prohibit you, if you are a restricted source, from giving someone a gift of travel if they basically have business in front of you. So that is in current law. May that provision need to be a bit more nuanced is an open question I will leave for the commission. In regards to the bundling matter, it's something we've certainly considered. I think it's a fair point, but we thought it was unfair to not be able to analyze that and bring something forth to the commission and then to put that in late in this bill. So I think it's something we can certainly analyze. But again, I think at this late stage to attempt to put that in without the sort of legal and policy analysis necessary, I just don't think that behooves us at this point in this process.
Good evening. Joe Kelly is my name. I'm here on my own behalf. I have a shirt tail, I guess it's called, relationship with Friends of Ethics. And I was a member of the grand jury in 2013-14, in which a report was submitted on this commission. And the main reason I came tonight was to speak on the behested payments issue. But I also, I'm going to be maybe a little out of line, but I want to really encourage the two new commissioners, welcome you. And as a citizen of San Francisco, lifelong citizen, I'm just so amazed that this commission exists. And I think you guys can do just a world of good representing the citizens, because I got to tell you, my experience is the elected officials now, once they get elected, they're kind of once removed, and it's a bit discouraging. But you guys have a lot of power. I also really encourage you to study the history of this commission, because for many years, this commission was dormant. But in the last couple of years, it's really got its feet under itself and is doing a world of good. I've been around San Francisco politics my whole life. Play to pay is, nowhere in the country is it more pervasive and evident than in this city. When I was on the grand jury and we were looking into this commission, and I saw this behested payment item, I said, what is this? It is. I have a family full of politicians, and to me, I guarantee you, Commissioner Keene used some terms people didn't appreciate, but that's what they are. That's what this allows for. Elected officials do not encourage people to donate without expecting something. It's not the nature of this beast that you folks are, looking over. And I encourage you to go back for years in the behested payments, because they're documented. And I promise you what you'll find is people making these payments who have significant issues in front of the city. And once their issue's resolved, and pretty much 100% in their favor, they're down the road. So this is, it's really discouraging. To me, I can't speak strongly enough for, encouraging you to proceed with this whole ordinance, because the citizens of San Francisco, of one I am which, I will appreciate it. I really will. So thank you for your time.
Thank you.
Good evening, Commissioners. My name is Bruce Wolf. I'm here today as President of the San Francisco Community Land Trust and the Haight-Ashbury Neighborhood Council. Just want to start off by saying, I think I could speak for all the nonprofits that are here that I've been working with on this. I'm not here to annoy you. We're not here to make your lives rough at all. In fact, you don't see us here that often, if at all. But when an issue does come up for us that has some serious effect, and we have like real world kind of an experience on it, and somehow either we're not understanding or maybe you're not understanding, there's some disconnect, that's what we're trying to get to. And that's kind of what I was hearing earlier when we first opened up for public comment between some of your questions and some of your comments to us. So I wanted to start out by saying that a lot of the nefarious people, characters, organizations that you are referring to that this will fix are some of the same folks that affect us and the work that we do. So we're in support of a lot of what is in here. I don't like pay-to-play politics. I'm affected by it every day. In my neighborhood, I'm affected by it every day. And it's a big concern. But when the law is not written in a way, the way, for instance, Commissioner Keene, the way you were explaining it to us before, it's like when I read the language, it's not speaking to me in the way you are wanting it to work. I'm reading it differently as it applies to my organization. So it makes it a little, I think there's the clarity or the specificity of who you are targeting needs to be more clear. Now, for instance, all throughout, we have heard about Airbnb, we've heard about Uber, we've heard about all those kind of pay-to-play type of nonprofits that we're all big and concerned about. But I haven't heard about one charitable organization that was breaking the law or that this law was seeking to correct. I don't like things like what happened with EdJu or PG&E at the beginning of this, the way the city got created. So I'm going to shift gears for a second on another topic, and that's around the bounty. So with regards to what happened, the tenants union brought up, the San Francisco Community Land Trust does receive city funding, and we do support and provide services to no and low income folks, Section 8, people on Social Security disability, veterans that are on can I have a few minutes just to finish my point? Thank you. And so if we are asset rich but cash poor, we have to scrape the can to get operational money. There are no grants for operational money, so we have to rely on donations and membership and stuff like that. But if somebody were to find a technicality that a public official showed up at a fundraiser that we're having tonight and makes a pitch for everybody in the audience to donate, and somehow somebody says, oh, there's a technicality in there, whether it's active or not under this law, we would still have to pay out for a lawyer, and it could be protracted for a long time, and it could seriously affect our budget. Seriously. And we've got assets that we're responsible for and people's lives who live in those assets. So I want you to just consider that if it helps at all. Thank you.
Mr. Wolf?
Yes.
The language specifically exempts the example you gave. If someone comes to a public gathering and says, give, that's not covered under this.
No, I understand that, and because the ban has been removed, I get that part. But at the same, I'm talking about with regards if somebody were to start an action privately, a private bounty, that some ambulance chaser or somebody that doesn't like us for some reason, and they started some action against us, that we would have to respond, and we would have to respond legally. I mean, I'm not going to be the one that's going to be showing up here. It's going to be a lawyer that we're going to be have to hire at $300, $400 an hour to do it. That's money we don't have.
That's a different matter, and I agree with you, and I got triggered with the concern of someone using the private right of action to harass any entity. I'm worried about that. But that has nothing to do with the behested payments. You're blending apples and oranges there.
No, I understand.
If someone wants to be an ambulance chaser or to be Donald Trump and just sue everyone whom they don't like or who does something for them, they can find something,
right,
whether it's there or not. But it's not in this law. It's not in what we're doing.
No, I understand.
So I respect what you said in regard to the private right of action. The rest of it, you're off base.
Well, okay. With regards to I was only using the behested part as just an example, maybe a bad example at this point in the game.
Very bad example.
Well, maybe just because this has gone through so many iterations,
It's gone through so many iterations because we've done it in order to accommodate the nonprofits.
I understand that.
We bent over backwards. The back of my head is gone.
I understand that.
And we've done it, and still we're coming. We're being villainized as a result of it, and we're being villainized falsely.
I don't think we understand what the language is saying versus what we're intending it in words, in conversation of what we want it to do.
The language is very simple. The language is very simple, and that is it addresses corrupt behavior of someone who is in a position to do somebody a favor, a politician or an elected official, saying to that person whom they're in a position to do someone a favor, give the Quentin cop because he needs some dough, or anything. That's all we're doing. And the fact that it might be a nonprofit doesn't make any difference if it's coming from that kind of a corrupt aspect of someone using their power to get another person to give money. That is pay-to-play type stuff.
I completely understand
That's all we're
what
doing.
you're telling me, but I'm thinking about what Commissioner Chu said at the beginning when she's got to explain this to her young child. Is it going to come over in that same way if that person were to read it? And that's some of the problems that I have. I'm an open government advocate. I'm staunch about that. I'm happy that you're focusing on pay-to-play. It's really important to me. If nonprofits weren't involved in any of this, I'd be standing here with the Friends of Ethics saying, rah, 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 go do it, okay? It's just that some of this there's so many different ways that this can affect us. And I think in the Interested Persons meeting, you heard a lot of those examples. And I think you're trying to do your best to try and help that out. But we're sitting here and we're still hearing that it's not quite that yet. It's not quite there yet. And because we're hearing a different interpretation. And so I hear the tapping on the shoulder kind of stuff and the one-on-one kind of stuff, but then there's the other part where it affects the nonprofit in a more broad way. And I'm just going to leave it at that.
Commissioner Cobb.
I just want direct answers to a couple questions.
Sure.
How much money do you receive from the annual budget of the city and county?
It depends upon, we buy properties using the Small Sites Program, so it determines whether there's a property available or not. But those properties are upward of $2.5–3 million sometimes. What we get from the city is not all of that, but we get a good chunk. And they're loans. They're not grants.
How long has your entity been in existence?
Since 2004.
How much total money do you estimate you've obtained from the annual budget in 13 years?
The Small Sites Program didn't officially launch till 2014, and I believe, I don't know, I don't have it off the top of my head, but we have...
10 million?
Maybe.
More?
No, I don't think it's more. I really don't. I don't feel confident to really estimate. I can tell you, like, we have 4 or 5 properties that are funded with this fund. So
you've answered.
Okay.
Maybe staff can ascertain that. Please do. And the other question is, What's your staff consist of? How many people?
We have 5 staff.
Okay, thank you.
And I'm sorry, Mr. Wolf, your operating budget for the 5
Our
staff?
operating budget is probably around, I think it's around 400,000.
And you have to go to outside sources to raise that?
Yeah, and we do get developer fees because just like any other organization that does this kind of work, we're afforded developer fees. Okay. So, but it's not. That's not where the operations really come from. That's to make sure that the operations of the properties are functioning properly, but it's not the office kind of stuff. Thank you.
Thank you.
Thank you. Kyle, you have...
Yeah, so just, again, want to make one clarification. So as far as the citizen suit provision goes, citizen suit or plaintiff suit, however you want to say, is actually already in current San Francisco city law. It's just that you can't recover 50% of any penalty. The court can enforce an injunction and can award costs and attorney's fees. So the frivolous nature of the thing is still possible under current law. It's just that now there'd be an award of 50% of the penalty, which would be $5,000 for each violation as the maximum amount. So I just want to clarify that citizen suits currently do exist in San Francisco city local law.
My main concern was that someone would use it as a political club in order to...
And they could currently do that, technically.
Okay. Thank you, Kyle.
And
Yes, sir.
also it's a financial incentive now, right?
Yes, sir.
Good evening, Commissioners. Thank you for hearing everybody out in this late evening. My name is Vinay Patel. I'm with the Asian Pacific Islander Cultural Center. We're a small nonprofit here in San Francisco. And I just, in hearing everything tonight, looking through the lens of a small nonprofit, who has an all-volunteer board, I just have a couple of questions for clarity based on the discussion that just happened here tonight. One is as we understand, if an elected officials do come to, like a gallery opening or something like that, and they'll make a speech or something like that, and it's great. Over 20, if it's over 20, it's good, because I don't think any elected official would ever come to anything less than 100 anyway. So, and we wouldn't even ask them if they did that.
Except Commissioner Kopp, when he was a
Commissioner Kopp, we're going to call you over all the time then. But one of the questions that I do have is that the 20 makes it sound like, look, that's a small group of people. We don't want that to kind of happen. But then, in some of the comments that you had, Commissioner Keene, was like, oh, if like the mayor were to say, no, this is good, and there was no quid pro quo to an individual, right? Then there's no quid pro quo. That's not the, what this is going after. So I had just a question, like if an elected official were to say, oh, that's a good nonprofit over there, you should think about giving, but they didn't have any kind of, quid pro quo. Is that still illegal? No. Or secondarily, but that's less than 20 though.
It's only a problem if the person whom the elected official or politician is asking is someone who is seeking some sort of benefit that politician or an elected official is in a position to grant.
Is there any kind of, and this is just open concerns, right? Like if you had a public event and there was people in the audience that we had no idea.
Public event doesn't matter. Public events are not covered by this.
Okay, and then my other
the politician could say at a public event, "I want you all to give the money to Commissioner Kopp because he's going to give me a kickback." That's okay under our law. It's because it's it's at a public event. Doesn't matter.
Right. And like this might happen too. I'm just throwing out scenarios. Like if you were like walking down or down the street nearby, and an official you guys bumped into casually, and there was somebody else that walked by and said, "Oh, this is a good organization to give to," right? As long as there's no financial thing there, that's okay.
Not covered. No,
okay.
Not a problem.
Okay, and then finally, only question that we ask: we have a lot of all the organizations I know have non-compensated board members, and so we just have a concern of like if it's a non-compensated board member, does this cause any other kind of burden to try to recruit board members to come on, your organizations, because most of us are not compensated to.
It shouldn't if they just read the plain language of what we're doing.
Okay, thank you.
You're welcome.
Thank you.
Good evening, Commissioners. Anita Mayo, Pillsbury, Winthrop, Shaw, Pittman. Section 1.124 will mandate that all committees obtain and disclose unnecessary information about business entity donors who contributed $10,000 or more in a single election cycle, including the business entity's principal officers and all city contracts or grants received over the past 24 months. This imposes an incredible reporting burden on all committees to collect and disclose this information, and on all business entity donors to provide this information. The public has a right to know which entities make contributions, the amounts, and the recipients of those contributions, but that right should not extend to unrelated information about the donors. This section appears to be in an attempt to discourage business entities from participating in city elections. Section 1.127 unfairly prohibits a person with a financial interest in land use matters and the person's affiliated entities from making contributions at specified times. The person must also file a report with the Commission. Since a person with a financial interest is so broadly defined to include not only the entity, but also its executive officers, all members of its board of directors, and developers, the prohibition on contributions would extend to all of the foregoing. Developers who are already subject to the reporting requirements of the Developer Disclosures Law should be exempt from this prohibition. Since California law requires 24-hour reporting for contributions and independent expenditures during the last 90 days before an election through the day of the election, additional pre-election reports are not needed and simply creates additional work for campaign treasurers. Section 1.170 permits a resident to recover up to 50% of any penalties imposed against a defendant in a civil action filed by the resident. This will result in unjust enrichments to residents and encourage frivolous lawsuits. Sections 3.203 and 3.207 create new conflict of interest provisions which are not needed. State law and regulations mandate recusal when financial interests conflict with an official's private interests. Numerous FPPC advice letters issued over the years provide much-needed clarity in interpreting the conflict of interest laws. These sections would impose additional standards which will create unnecessary confusion. Because state law currently provides comprehensive regulation of conflicts of interest, these sections are not needed. Finally, today's version of the legislation unfairly expands a fundraising prohibition ban imposed on board and commission members from city elected officers with appointing authority over the members and candidates for such offices to all city elected officers and candidates. Only fundraising on behalf of the members of the Board of Supervisors is exempt. The ability to support candidates of one's choice should not be eliminated simply because an individual chooses to serve in a voluntary position on a city commission or board. This provision is unreasonably broad and not narrowly tailored to avoid the unnecessary abridgment of associational freedoms guaranteed by the First Amendment. Thank you.
Thank you.
Good evening, Commissioners. My name is Peter Cohen, and I'm with the Council of Community Housing Organizations. Been listening to the testimony, and I guess I'm one of the nonprofits in the lineup as a representative. And I want to say respectfully, Commissioner Keene, I have not heard anyone here tonight villainize either you individually or this commission. Folks have been here, I think, very earnestly expressing concerns, questions, confusion about the substance of this very complicated legislation. Most of us are not lawyers, we're not ethics experts, we're lay people in the nonprofit sector doing various kinds of community-based service work. And I think the fact that folks have taken their time to come to this commission and work with you and staff is in no way disingenuous or dishonest. And I really hope that we can have a respectful discussion here. If you want to throw some hardball questions at me, that's fine, but I don't think that's why we're here. We're here to try to understand how this may impact our community, because this is permanent legislation and we want to make sure to help you get it right. So with that in mind, I just want to thank again staff for taking the time over these last couple of weeks to go through in a couple of interested persons committee meetings, some really good and useful cartoon diagrams to help us lay people break down the previous proposal. Appreciate also that you were compelled to remove the ban on behested payments and try a different approach. It is an approach, and I'm not a process person to call that card, but they came out to us on Thursday evening. And we had very little time, less than 24 hours, to digest it and provide some sort of feedback, which we did in a very short letter to you at 5 o'clock on Friday afternoon, expressing still some concerns and reservations about what exactly this is getting to and how it may affect our community's work around fundraising, but certainly not with the level of time to go into the weeds that we might want, which is in many respects why we're having all this back and forth. This is a real-time learning process without the benefit of working with your staff and getting educated and being able to ask questions. So we're in a very vulnerable position of asking what might seem some very naive questions about a piece of ordinance that frankly was written evidently earlier in the week, and we are just now here learning about. So again, it's of concern to us. We do good work in this city, and we made it clear from the beginning of this process we have no interest in tampering with your efforts to make restrictive any kind of corrupting behavior. But we are going to stand strong in making sure that there are no unintended consequences. I see nothing wrong with that. We have very specific amendments that we proposed in our letter that don't have anything to do with the new section that, as Debbie Lerman pointed out, have not been addressed, and we think those are important. And we still think that this piece needs to be looked at more closely before we're going to say, okie doke, this is just fine. So it may not be behested payments, but it might smell a little bit like it's getting at the same problems in disguise. And I'm happy to answer Commissioner Kopp's questions, which I think are coming.
They're coming.
Okay.
How long has the Council of Community Housing Organizations been in existence?
About 35 years.
And
before my time.
That encompassed the years in which Proposition J was in effect, correct?
Yes.
Okay. And did you have any violations of law under Proposition J?
Not that I'm aware of. I've been with the organization 6 years.
Okay. And do you supply or furnish services to any low-income or no-income people directly?
We have 25 member organizations that provide the services.
I know you have member organizations.
We do not. We are a coalition of our organizations, yes.
And how much, if at all, do you receive from the budget annually of the city and county?
None.
Okay. Thank you.
You're welcome.
Hey, Mr. Cohen? Mr. Cohen?
Commissioner Rennie.
As you apparently met with Commissioner Kopp, you also met with me before the last meeting, and many of the changes that occurred in the redraft of September were really in direct response to issues that have been raised by the nonprofit community.
Correct.
Right. And one of the things that it is, it focuses only on elected officials. And you were telling us our big problem was that board members would be nervous and all these problems. And you were concerned about your galas or your fundraisers, and we've dealt with that.
Mm-hmm.
And yet, and I think what Commissioner Keene was reacting to, and I react to in a certain way, is I can't see that any of the changes we've made have satisfied you. You have the exact same, all the nonprofits have the exact same complaints that it's going to stop our fundraising and it's going to do this and it's all sorts of that. I don't know what we can do.
Well, Commissioner Rennie, we actually don't have the exact same complaints. And I think in both the letter and what you've heard from folks here tonight, taking out the ban on behested payments, folks, thank you for that. It's a better direction to go. There's a lot of questions here. I don't think you've heard the same specific complaints. There are concerns that we don't understand how this is going to play out, and under the scenarios that you put in your little cartoon diagrams, this is a completely different approach. We don't have the benefit of seeing this through. Anything of value is a very sweeping definition, and it's hard to understand exactly what that means. So, Commissioner Rennie, it's not so much that this is exactly the same as the previous proposal. or the folks are making the same exact complaints. This is, again, as you heard from the Alliance for Justice, a significant move of changing the way contributions are made. And we just want to make sure we understand exactly what it means for the work that we do. So that is as much of a question about its implications as a critique that you've somehow done something wrong. Thank you.
Hello, Commissioners. I'm Larry Bush from Friends of Ethics. I was also a member of the Civil Grand Jury of 1314. I'd just like to run through a few facts about, first of all, about behest payments. We did a spreadsheet on those for the last 5 years. It totaled about $23 million. We were very concerned, as other people have been, about what that meant for nonprofit organizations. And going through the list, the number of nonprofit organizations that were providing direct services to low-income people who received money through behest payments was 0. There were 258 different donations, $23 million, but they were not going to nonprofits providing direct services. Instead, what you had was $3.5 million for the America's Cup, because Larry Ellison obviously needed more money from the people of the city. You had $1 million going for City Hall celebration of the centennial. You did have some nonprofits that received money, but they were primarily for conferences. Spur received about $100,000 for its Silver Spur Award, in which the mayor made phone calls to people who then gave money to Spur, and then Spur provided awards to the mayor's department heads. It was a very closed circle. So that's what nonprofit record is on behest payments. In terms of, was there a quid pro quo? Well, I'll give you one example. Kilroy Realty was asked for and gave $1 million. And at the same time that they gave $1 million, they got an additional 6 floors approved by planning on a building at 350 Mission Street. 8 Washington, otherwise known as SF Waterfront or Partners, whatever it's called, was asking the mayor to endorse their position on a ballot measure about the wall on the waterfront. They gave $10,000. The mayor appeared in their TV ads and their print ads. The Soft Drink Coalition wanted the mayor to stay neutral in their measure. They gave $10,000. The mayor stayed neutral. The biggest one was Google buses. They were facing a lawsuit from citizens, and so they gave $6.8 million, but not as a behest payment, directly to MTA. What that did was provide free bus service for kids for 2 years. It just happened that they gave the money a few weeks before the MTA was to give a pilot program that was going to go for what? 2 years, the same 2 years as the contribution that they were making. That's why people have questions about whether or not there is a quid pro quo going on, because there's plenty of that looking at it. We talked about private right of action. I just mentioned in passing that the city new law on housing includes a private right of action so that nonprofits can sue to enforce on eviction. We also have had for some time a private right of action on environmental violations in the city. So that's not something that's totally new to any of us. We went through, and I can send it to you, but MapLight, which is a very good national organization, did a survey of people who were seeking permits that were worth over $100,000 and who also gave contributions to city officials. And that showed that about $800,000 went in just the last election to city officials from people who were also seeking permits at the same time. And I'm happy to forward that record to you.
Excuse me, Mr. Chairman. To Ms. Bloom, do we have that survey?
MapLight survey?
Hmm?
Yes, the MapLight survey?
Yeah.
Yeah, we do.
Make it available to me.
Sure.
I want to echo what was said earlier about travel. I think that the travel is pretty much a clear-cut case of people who are
hitching a ride for their issue, not just on the plane. And bundling contributions was also something that we addressed in Prop T that passed last November, in which we said lobbyists could not bundle as well as contribute. It's been a big problem for some time that you couldn't write your own check as a contractor, but as long as you didn't put your check in the stack, you could go out and collect checks from other people. So that's the reality of that. There's a lot of other things in this, and I'd like to talk about them. If you have any questions, I will talk about them.
Commissioner Kopp.
What's that $23 million figure applied to, and what years?
That was from 2012 to 2017, and it was the behest payments that are on the webpage for ethics. That's where we took it from.
Okay.
It's true that you report a contribution of $5,000, but once you've made a $5,000 contribution, any additional money you give after that has to be reported, even if it's $100. So when you look through the list, you'll see there are some people who are $100 donors. That's because they gave earlier.
Thank you.
Thank you, Mr. Bush.
Thank you.
You could be here for the next 3 hours listening to Mr. Bush, and it would be very entertaining. I would like to show the behested payments list, and we don't know how to turn the equipment on. This is Elena, my assistant. Not from the main control. Oh, shucks.
Sure.
Well, I just want to make a statement regarding my name for the record, Charlie Marsteller. And I wanted to say, after last month's meeting, I received comments from 2 members of the public who wanted to see more examples of this list, but unfortunately we can't seem to get the equipment working. It's up. Ah, very good. Can we focus? I think you have a zoom. Oh, there, zoom on the top.
Interesting.
Okay, very good. Sorry for the delay. I thought that the public, as a result of these calls from the public who urged that I show the full list, I thought the public should see the list. After all, we talk about this list all the time, but the public has not really seen it. I did want to say that there's a lot to say, but I think the bottom line is what Commissioner Chu said, and that is we want to get to the big picture of what it is we are trying to accomplish. And I think it's pretty clear that we've kicked a hornet's nest. Now, we've seen concerns by 501c3 organizations, but basically all of us are on the same concern regarding the issue of corruption. And I would urge all the commissioners to join tonight to send this legislation to the board. And in that process, this whole issue of behested payments will be opened up for consideration and debate. And I think it needs to be done, and it's for a very simple reason. The FPPC came up with this concept back in '97. It's now 20 years old. We're now seeing the evolution of this dynamic in pay-to-play San Francisco. And if you want details on what looks to the public as quid pro quo, we can give you those things. But I think the best course right now is to send it to the board and let the public come forth, the greater public, not just FOE, Friends of Ethics, and the 501s, but the greater public to come forward and discuss how it looks that their elected officials are basically clearly the best fundraisers for anybody, and it looks like it's pay to play, it looks corrupt, it looks like racketeering, or it looks like bribery, or you could put a number of names on this, because the public will, because there's going to be clearly an appearance of conflict of interest and an appearance of corruption to the public. And that's who your boss is, the public. So I wanted to thank you for your hard work on this issue, and I hope to see you over at the board.
Question.
Commissioner Kopp.
Mr. Marcel, are you recommending transmission, adoption, and then transmission to the Board of Supervisors as is, without a ban on behested payments?
I'm calling for the ban on behested payments as you've defined it in the bill. And the bill is can be amended any way you deem fit.
I know it can be amended, but as is, are you recommending?
Well, no, I'm suggesting that you go ahead and amend as you wish.
Right, I understand.
And then send it forward.
Commissioner, Mr. Marsteller.
Sorry.
Commissioner Chu.
You put, I wasn't able to see because my screen was kind of
I'm
a
sorry.
little
It's the same document that's been submitted.
You said that there were, so this was a list of the behested payments. And do you have more information that shows what these payors, the people who made the payments, received from the city?
That's problematic, but Mr. Bush could probably make a very long list. As I say, he could talk to you 3 hours tonight probably on such an issue. But of course, is it sufficient for a proof in a court of law? No. It's going to boil down to the appearance.
Right. No, I understand that, but I think it would be very helpful, at least to me personally, is in addition to the list of behested payments, if it's $23 million over a 5-year period, what did they receive then in return? So
well,
I heard
for instance,
six-story increase. So that kind of information is very helpful to me.
Yeah, for the lists that have been given to you, the MapLight list is much longer than the list we put on the screen. That was an earlier list we did off of your website. MapLight's computer experts were able to merge some of our databases and came out with a longer list. The other, and it started earlier, 2012. But it also, there's a list of people seeking land use permits, conditional use authorizations, increases in building heights. Those are called permits, essentially. And that list has been submitted to you as well by Mr. Bush, and it's in the FOE packet. But whether we're matching quid pro quo, no. The list, for instance, for land use permits, those permits are basically comprised of individuals who have made behested payment, donations. At the same time, they have business with the city, i.e. permits, applications pending.
Okay, thank you.
Calvin Welch, San Francisco Information Clearinghouse. I was prepared this evening to come and thank the Commission for the changes in the legislation until I got here. And somehow raising questions, remaining questions, somehow associated nonprofits, at least as far as Commissioner Keene is concerned, with supporting corruption. I have to listen to Mr. Marsteller, who says he supports the legislation, except you ought to amend it and reverse the concessions that you've made, I think, to common sense, because they have a long list of behested payments that never went to nonprofits that provided direct services to low and moderate income people. which is basically the nonprofits that are here tonight. You don't see the opera here with us. I have no idea what your reference to the opera or the symphony is. They've not been involved with us. We've not been involved with them. We are faith and community-based nonprofit entities, many funded by the city, some not, that provide direct services, health, human services, and affordable housing services to the poorest of the poor in San Francisco, to the most vulnerable populations. And somehow, Commissioner Kane, we're at the very heart, the nexus of corruption in San Francisco. Yet when you give examples, it's Google, it's Airbnb, it's not us. What are you talking about? And more importantly, it's very difficult to agree with a commission that is in the midst of continuing to circulate innuendos about political corruption. I don't know what else we need to say. We support the ordinance as drafted. We support the change in the ordinance that this commission, I assumed until Mr. Marsteller spoke, you guys were in agreement with. We have lobbied you as we have lobbied as people are supposed to do in trying to get our points across. What is corrupt about that? And why is it that we're defending corruption when all we're defending is the ability of faith and community-based nonprofits to continue to provide services that otherwise would not be provided? That's what's at issue here. I don't appreciate the assumption, the assertion, the innuendo that nonprofits are somehow in support of political corruption in this town because Google gives money to the city and county of San Francisco to provide youth fairs. How does that implicate a nonprofit? In what regard are we corrupt?
The problem, Mr. Welsh,
yes,
and I never
please.
Accused people of being corrupt. And what I said was, and what
you accuse nonprofits of being corrupt.
Ask the question. No, you know.
Listen to your opening remarks, sir.
Why don't you let me answer? Let me answer. And that is by the nonprofit. You're correct. None of this stuff does affect nonprofits. But by the nonprofits coming in and making these very passionate arguments against this type of anti-corruption legislation, which doesn't affect you, it lends...
Now it doesn't affect us because you changed it. It affected us in the beginning because of your ignorance.
Now, wait a minute. That's what.
Yes.
We changed it as at your request.
Thank you.
And you're still coming at us.
Tough people to agree with.
You're still coming at us. You're still coming at us and saying it's no good. That's what this whole thing has been tonight. So that is totally disingenuous in terms of what you said.
No. We said pass this version. Pass it on to the Board of Supervisors.
Well, so you're saying you're in favor of what we have here?
I'm saying pass it on to the Board of Supervisors.
We'll take.
Of course, we're not in favor 100% of this. We think you got it wrong on private right of action. We think you have no idea how many nonprofits providing health and human services in this town are threatened with lawsuits by neighbors who don't want those services.
We're talking about behested payments, and so far what has been said has been an attempt to give some sort of veneer of protection to non-payments in order to protect, behested payments in order to protect nonprofits. That's totally disingenuous.
What's disingenuous? Thank you for removing that language. That's disingenuous. That's as honest as I can
Chairman,
make it.
Point of order.
Commissioner.
Mr. Welch and you can discuss this privately.
I'd be delighted.
I'm sure you would. Wait a moment. I take that back. I don't want to get in it. But I do have a question, Mr. Welch. Tell me again that organization.
San Francisco Information Clearinghouse, not funded by the city and does provide direct services.
Okay, how much by the city?
Is not funded by the city.
Oh, not, okay.
Never has. We would ruin our credibility if we were funded
All
by
right,
the city.
thank you.
You're welcome.
Yes, sir.
Good evening. My name's Douglas Yap. This is my first appearance before this commission. I'd like to make it official that I and others that have been viewing it very quietly are in support of the staff of this commission. In my opinion, the previous executive director did a good job. Unfortunately, it wasn't the correct job. This current administration is off to a good start, and I would like to put it officially on the record that you have very many supporters viewing your work closely, and it will affect other parts of the country. So keep up the good work. An example I would like to use is that it's kind of like the thin blue line. You have to hold the line, and eventually you have to get strong enough to push the line forward. In my opinion, the previous group here did a good job. In my opinion, it looked a lot like obstruction of justice. Another thing I would like to point out is that when you talk about different philosophies of politics in California, let's put on the record, there's one that is quietly and very secretly known as whisper in my ear. I'm sure all the old-timers know exactly what that means, and you shake in your boots because you know all the other persons involved. But let's put it on the record. If we're going to talk about the other names, let's call it whisper in my ear. For the record, I support Mr. Kelly's statements and also Mr. Marsteller's. If we're going to argue about it, let's argue about it openly. Eventually, the winners will be the citizens of San Francisco. Let's put it this way. Crime festers and grows because people like it that way. We have to make it unlikable. And let's put it this way. The next growth industry in this country is not social media, it's not video games. It's something some of us would like to call corruption busters. Many of us are getting old, and we would like to invite some of the so-called best and the brightest to join a new field and make a name for yourself, just like Elliot Ness made a name for himself. We need a bunch of people, young, aggressive, and smart, that owe nothing to the power base and basically are going to say to them, your time is over, time to go to jail. Thank you.
Thank you. Any further public comment? Okay, commissioners, do we have a motion in regard to the matter?
I'd like to make a...
Oh, I'm sorry, commissioners.
I was holding off my comments. First of all, I want to thank the staff for taking in the public comments made at the last meeting, as well as the two interested persons meetings. And I was glad to see that the strictly banned language was taken out from this version. I started my career, my first job out of college was with a nonprofit, Self-Help for the Elderly. From there, I learned the importance of community service, that the importance of nonprofits are serving the most vulnerable population. I work with nonprofits for the past 30 years. Currently, my 96-year-old mother is able to live at home independently because of another amazing nonprofit, Unlock, that's kept her living in a safe and dignity environment. So for me, this proposal is very personal. Besides my personal experience, I also listen to the comments from the public. And the nonprofits that I work with are very hardworking, very devoted folks who work with the most vulnerable, left behind population that most of us may write a check once a year, but would not want to work full-time with. It's a very challenging job. And I think that I share many of the folks' sense that their challenge of getting financial support has always been real. I remember years ago, it was a tough time to get funding. In a perfect world, the folks with the big checking accounts would whip up a check to support all these worthy causes. But unfortunately, they're not connected to the most vulnerable population in our city. And oftentimes, we need folks who are elected to do good, to support the most isolated and vulnerable population. They're elected to do that. And oftentimes, they work with nonprofits to really help each other. This proposal, and I want to make it really, really clear, I am for good government, I'm for clean government, I am for transparency, like all of us here. The problem that I have with this proposal is even with the removal of the specific ban language, I still find it troublesome. And maybe some of the folks who testified earlier was right. Maybe we see things in a different way. When I read the conflict of interest language, I see it as, in many ways, it creates more restriction to the nonprofits, specifically because of the addition of anything of value. For nonprofits, of course, grants, financial supports are important, but they rely on volunteers, they rely on other support to sustain the programs. Oftentimes when people host walkathons, they can't get the Googles of the world, the staff to come, because the Googles of the world may not know that there's a senior walkathon in the city. So if, let's just say if a public official happened to meet with a nonprofit and find out that, hey, there's a walkathon in the city, we need volunteers, we need folks. And the public official happens to find somebody who came to the office for a meeting and just say, hey, I just heard this great event for your staff to help out. Great cause to support seniors, Meals on Wheels, whatever it is. And under my reading, it's no longer allowed. And for that, for the anything of value clause, it gives me pause to look at this as it creates more restrictions for the nonprofits. And most of the nonprofits are not the well-to-do organizations. Most of them are struggling. Many of the staff are still getting minimum wage. So that's one thing. The second thing I'm concerned with is the addition of the board members and also the nonprofit folks who are serving on boards and commissions. I like to think that nonprofits, because they're in the front line, they are exposed to a lot of things that many of us would want to learn from, would want to work with them to build better policies, to build better programs. So it's a great asset to have them to serve on these boards and commissions. But under this provision, if I were someone in nonprofit, I wouldn't want to serve on these boards and commissions because of the fundraising restrictions. So based on those, and also I asked the staff before, if the private right of action is already in the books, the change is the financial incentive. And not knowing what the LA experience is, because I don't like to compare us with LA, I still think that under the $50,000 incentive, it is going to create more frivolous lawsuits and the potential of that. And more importantly, I think it's going to create a chilling impact on folks who are what I would call new San Franciscans, who are not part of the traditional communities, who are now learning the importance of civic engagement, who are learning to get involved. And we encourage them to do that. But with this private right of action provision, I can see someone who might have done something technically not, because they haven't done this for the past 3 decades or what have you, they get dinged because somebody looks at this new provision and just say, hey, I can file this and I can get some financial income out of it. So because of all these, I know that people may think that, hey, you're stretching it, but based on my limited experience working with nonprofits, working in nonprofits, benefiting from nonprofits, I see these as real concerns. And I think that's why we're hearing from some of the folks that they're not against, they're not for corruption, they're not against good government, neither am I, but it does create a lot of confusion, and the confusion is the bottom line impact for the nonprofits. It's like, how is it going to affect their future opportunities to raise fundings to support the programs? And all of us know they have to brace for a real possibility for the next 3 years, their budgets are going to be cut drastically. So for us as a government body, we should encourage more support to these vital services. And I think that from my reading of the latest draft, these are unintended consequences. Nevertheless, for the nonprofits, at least for my reading, is pretty real.
Andrew.
With all due respect to Commissioner Lee, none of the illustrations that she gave would fall under the behested payment provisions. And what concerns me is that when we did Proposition T and we did Proposition C, the only opposition came from the nonprofits. And yet they've been in effect. There's been no impact on the nonprofits, but they're always raising this specter of some boogeyman when it's so clear, as Commissioner Keene has said, is what this legislation is directed at is the public official who has a matter before him or her going to the individual who has an interest in that matter and saying, well, I'd really like you to give money whether it's to my political committee, my independent committee, or to some charitable organization, to stop that public official from doing that. Now, as Mr. Bush has pointed out, none of the behested payments, generally speaking, went to charitable organizations. And I mean, we can say, well, we can't pass this because it might have an effect on the fundraising from some charitable organization, and we just let the public official do what he or she wants to do to benefit whatever committee it is that he wants to benefit. And there's no implication. And I just think my sense is we ought to pass it to the Board of Supervisors, and the public will have plenty of time to make whatever changes. I mean, the board can make whatever changes they think are required. But certainly I don't think we ought to stall getting it out of the commission and to the board.
Commissioner Kopp?
Okay, well, I won't second the motion. I'll leave it to the chair, perhaps, to do it. Let me go back in history, and I'll start egotistically. One of the notions advanced publicly after I was appointed last year by the Board of Supervisors of this commission was the almost 3 decades in elected public office and political campaigns. And I'll be egotistical in saying that is accurate. And I can recall, and maybe the only other person in this room might be Mr. Welch, if he's still here. Yeah. And maybe Mr. Marsteller, that nonprofits became popular in city government about 1973 and 1974, not by a liberal source, but by a conservative source. Then Supervisor John J. Barbagelata, who believed that it made sense for the taxpayers for nonprofits to execute responsibilities in lieu of city employees because nonprofits would do it cheaper and more efficiently. And now, some 47 years later, it's a fact of life. And I hope I didn't bother those worthy San Franciscans whom I asked about delivering direct services to low-income and no-income people. I also want to express my pleasure at tonight's meeting, Mr. Chairman and fellow commissioners, because this is the first meeting of now 12 meetings since September 2016, which was serious in all respects. No antics for television and no acting in ways which certainly offend my sense of civic engagement and conducting oneself in civic affairs. This ordinance as proposed doesn't include a ban on donations. In my opinion, it should. It has been, in the chairman's tautological phrase, refined down. It's been watered down. And I'm not going to reignite an argument about people testifying from nonprofit entities, whether they deliver direct services to low-income people or they don't, or whether they're congeries of different organizations, but it should. Nevertheless, I think I've had enough experience in the Board of Supervisors and in the state legislature to realize that you don't get all you want as an individual official with an individual vote. So I will take any suspense out of the equation by saying I will vote for Commissioner Rennie's understandable motion. I want to make a couple of other comments. I think the gentleman who was part of Senator Sanders' campaign for the Democratic nomination for president has departed, but I'm satisfied that the provision stricken, I think it's section 1.163.5, would probably be invalidated in litigation. And the public should know that such a lawsuit, just one lawsuit, is estimated by the city attorney to have a cost of $300,000 to $500,000 to taxpayers. And it isn't proper to take an action which would cost taxpayers money, in my opinion, in all probability. I also am cognizant of the concerns about the private right of action. Having been a lawyer for so many years and having participated in state legislation which grants private rights of action, I want to try to allay those fears. First of all, people should be reminded that, 20, 21 years ago, the legislature passed legislation which is commonly referred to as allowing slap actions. In other words, if some big corporation or somebody sues a citizen or a couple of citizens or maybe 10, 20 for some purpose to prevent enforcement of law, the law in California now recognizes that can be deemed on a motion as a strategic lawsuit against public participation in civic affairs. And there's provision for an award of attorney fees and the rest of your expenses in that event. And then secondly, the courts also, if it's somebody who, in common parlance, is a annoying, pesky private litigant, the courts have the authority to declare that person a vexatious litigant and prevent the filing of lawsuits except with an express court order after due consideration. None of us knows what will happen to this ordinance in the Board of Supervisors. We don't have to depend upon campaign donations for our exalted positions. But I will state now that I reserve the right, if this ordinance is bowdlerized by the Board of Supervisors, to assert the Commission's legal power to present it in this form directly to voters at the earliest possible municipal election.
Thank you, Commissioner Kopp. We're going to take a 10-minute break right now, and we'll come back and resume.
SF Gov TV, San Francisco Government Television.
Yeah. How are you? Write down your internet because I got a letter to the Sacramento a week ago, so I'll send you a copy. Okay, sure, do that, please. Oh, that's good.
San Francisco weather. It was like so hot today, but by the time we leave tonight, it'll be like 40.
Tomorrow's going to be hotter than Wednesday.
Yeah, that's what of my appointments do. Except yours is smoother than one of my
Can't complain though.
best friends who made herself brunette and blonde at the age of 65, maybe. Huh?
That's awesome. Like your license.
Okay.
Get up by now.
Mr. Chairman,
Yes, we're back in session. Commissioner Kopp.
I mistakenly apprehended a motion had been made by Commissioner Rennie to approve the presented ordinance. I was incorrect, and that's just as well.
I was about to
because
take it as a motion that he did make it.
Because I want to amend one inapplicable provision on the first page in the description of the proposed ordinance, line 22, the words, and 15, appropriate $200,000 to the Ethics Commission to fund administrative and enforcement costs for this ordinance, period. And quote, no such provision is in the body of the proposed ordinance.
Okay. Commissioner Rennie, would you accept that as a...
What page is it?
Huh?
What page are you referring to?
Page 1 of the actual
okay.
proposed ordinance, Commissioner.
Yeah, I'll accept that, that deletion and would move that we submit, that we approve this ordinance and submit it to the Board of Supervisors for consideration.
I think Commissioner Chu.
Yeah, so Mr. Kundert, you had mentioned earlier, and forgive me if I don't have this correctly, that there was this kind of a state law analog where a private right of action had been modified in some way in order to eliminate or reduce the potential for politicization or the use of it as an offensive kind of tool. Could you elaborate on that a little bit?
Yeah, and unfortunately, I got it sort of secondhand anecdotally from someone who used to formerly worked at the FPPC, and apparently when they first inputted or enacted that provision, there was some, whatever you want to call it, vexatious litigation that occurred, and that has since subsided. But if I stated that it was because of a rule change, I misstated. I'm not sure if that's the case or if it was just from other sort of policy enactments by the FPPC saying we're not going to accept, certain types of complaints, et cetera.
I mean, I have a question to my fellow commissioners and also to staff. Is there any way to add language that could help reduce the opportunity or the risk of political use of or punitive use of the private right of action?
Yes, Ms. Bloom.
So we did think about that possibility, and we attempted to address it by including factors that the judge would have to consider when assessing penalties against private litigants. And one of those factors is ability to pay. So if it's a indigent individual or a nonprofit without any assets or funds that would be able to use for a payout like this, there would be no incentive to go after them in private litigation.
I think Mr. Bush has some
I was just my understanding of the history of it was that Tony Miller, who was the Deputy Secretary of State and then Acting Secretary of State, ran and lost. But after he lost, he decided to open a private practice and began filing complaints on all kinds of de minimis issues as a new income source for him. And that's what annoyed the FPPC, so that they then went through and amended it so that it couldn't be used as just a puppy mill for taking care of that.
I see. Okay, thank you.
Okay, we have the motion by Commissioner Rennie, seconded by Commissioner Kopp with the amendment, the friendly amendment. Before we vote, we're gonna have to hear from Mr. Chen in regard to some of the implications relating to our sending it to the Board of Supervisors. But since we have the motion, do we have public comment on the motion? Okay, Mr. Chen, you want to advise us as to the procedure relating to the way we're going to be voting now?
Yeah, just a brief reminder for the benefit of the Commission and for the public, and just to echo comments or guidance that Mr. Kundert already provided. So because large portions of the city campaign finance laws and the city's conflict of interest laws were initially proposed and adopted by the voters, it is a special vote requirement that further amendments to these sections of city law require a supermajority vote of this commission. So for this legislation to proceed to the Board of Supervisors for their own views on this matter, the commission would need 4 out of its 5 members to approve this to make it to the Board of Supervisors.
There was another avenue that Mr. Kundert mentioned in regard to if we don't get a supermajority, that we can still get it to the board. Mr. Kundert, do you want to weigh in on that?
Yeah, and I can also address that and certainly let Mr.
Oh,
Kundert
yeah, sure.
elaborate.
I'm sorry.
No, not at all, not at all.
I thought you...
Yeah, so there's also, I guess, the possibility for, hypothetically, if the commission were to have 3 of its members vote in favor of this proposal, there is a somewhat limited ability for the staff to take further steps on the proposal. It would not permit the Board of Supervisors as a whole to consider it. It would now not allow a committee of the Board of Supervisors to consider it either. But there could be some sort of more limited engagement or dialogue by which the staff, for example, could contact an individual board member's office, get their views on the subject, see if that's an individual member of the Board of Supervisors wishes to introduce the legislation on their own. But at some point, if for this legislation to move forward through the legislative process, it would at some point need to come back to the Ethics Commission for 4/5 approval. So there could
But
be
what
some.
you're saying is in the event we didn't get 4 votes, say we got 3.
Sure.
You said the staff, but also members of the commission or the commission itself, the 3 members or one of us, whatever, could try to prevail upon one of the members of the Board of Supervisors to go forward with it. That's what I understand. Is that correct?
Right, but just to be clear, a member of the Board of Supervisors could introduce the same legislation at the board, so initiate the legislative process there. But again, it would need to come back to the Ethics Commission at some later point for 4/5 approval.
After assuming they passed it.
No. So the board, again, so the same rules would apply. Neither the full board could consider it, nor could a board committee consider it until there's a 4/5 approval from this commission.
So what could the one supervisor do then that we?
Again, that's why I've referred to it as somewhat limited ability of staff, or perhaps the commissioners take a lot of further action on it. There wouldn't be.
Sounds like a non-existent ability, and we could.
It's I think fairly limited, but maybe Mr. Kunder has some other ideas on that front. But again, the way that the amendment process is set forth for the city's campaign finance laws and conflict of interest laws are unique, because a lot of this stuff, a lot of these materials, a lot of these provisions were initially adopted by the voters. Now, the general rule is anything adopted by the voters can only later be amended by the voters. So there's a little bit of a wiggle room that was built into these proposals that allows for amendments not to have to go back to the voters, but it requires, again, supermajority approval of both this commission and the Board of Supervisors.
So I'm sorry, the supermajority voting requirement applies here at the commission and at the Board of Supervisors?
Yes, correct. And thank you for that clarification. So amendments require 4/5 vote here and 8 votes of the board, or 2/3.
So that, as I understand it, if say only 3 commissioners were in favor of it, one of our action would be to say, let's find out what we need to do to get the 4th vote. In other words, how do we have to change it that would get 4 votes and modify the ordinance to deal with the problems, for example, that Commissioner Lee talked about that she saw in the present language. We go back not necessarily to the drawing board, but go back to work with staff to try and see whether you can satisfy the 4th member of the commission.
Yes.
Okay. All right. So
Just to be clear, so from a process standpoint, then, if the commission doesn't vote in favor for 4 out of the 5 to proceed with the ordinance as drafted, then we could still take this up at the next meeting. Then, is that?
Yeah, I think that would certainly be up to the commission. If for some reason the commission didn't reach that 4-vote threshold currently, the commission could, of course, continue the matter to a future meeting, with direction of the staff to address specific provisions or address specific issues. There's a whole variety of things that obviously the commission could continue to do to work on this proposal.
Okay. Commissioners, are we ready to vote?
Yeah.
All right. Commissioner Chu, Vice Chair Chu.
I share Commissioner Lee's concerns about Section 3.207, in particular the phrase "anything of value." So I would vote no.
Commissioner Rennie.
I vote aye.
Commissioner Kopp.
Aye.
Commissioner Lee.
No.
The chair votes aye. So we have a 3-2 vote.
I would make a motion that we send it back to the staff to confer with both, I guess, the commissioners who have indicated reservations and see whether or not, what language they would suggest to make the ordinance in a form which they would be prepared to support.
Is there a second to the motion?
Second.
Okay. Any discussion on the motion? Let's hear public comment, if any, on the motion. Mr. Bush, I knew you wouldn't fail us.
I'm just wanting to get clarification. Is it going back only on the issue that Commissioner Chu raised, or is it going back on other issues as well?
On whatever issues that would come up in regard to discussions on the part of the staff with Commissioners Chu and Commissioner Lee.
Then I would request that during this period, there be another interested persons meeting so that you can obtain additional public comment or written comment if that's the way it's going to come in. Thank you.
I think that's probably a good idea.
I think that's a terrific idea.
I saw the shoulders slump of all of our staff.
I'm all in favor of interested persons meetings, but I will say, for your information, we hear the same thing you hear here every time, and it doesn't change.
Yeah.
So they're a little
Okay.
frustrating.
So the meetings will be between the staff and Commissioners Lee and Chu.
And Mr. Chair, may I suggest that maybe the next interested person meeting be held in a community setting so it's more conducive for the public to attend to express their views?
Mr. Cohen.
We want to get this ordinance right with you. This is not a stonewalling process, so appreciate the opportunity to go through. There were some, this issue on the behested payments in whatever form it is the primary one, but there are some other very specific issues that we would at least still like to get a response from staff if they just disagree. They're on sort of lingering issues. I do want to respectfully reply to or respond to what I just heard from staff. A lot of us engaged for several hours over 2 interested persons meetings, and I thought they were very good discussions. You were working very hard under tight timeline, but that revised ordinance did not come out until late afternoon on Thursday. So to say that nothing changes, I think, is a bit unfair. We were hoping to have had a chance to see the staff responses to the conversation and be able to digest them and have some kind of a dialogue, and I think that was what was missing. So we'd like to have an opportunity to continue working back and forth. I think we're all intelligent, thoughtful people, but I don't think that we're just kind of like robots saying the same thing over and over. We're genuinely interested in seeing how this ordinance takes shapes to achieve its goals and giving you feedback on that. So with that, I appreciate the time.
Well, Mr. Cohen,
Sure.
on 2 occasions, the most recent time we met, but earlier, I think on Proposition T, I said, propose the language that you want. You keep telling us we don't come up with the right language. What language are you willing to accept
Well, Commissioner
on BS payments?
Sure. Commissioner Rennie, to be very specific, on September 18th, we submitted a letter. It was a page and a half, very straightforward, with very specific amendment language to the staff with suggestions on how to modify all of the issues we had suggested, specific code sections, language, and everything. That's not what came out the back end of the sausage grinder when the revised ordinance was released on September 21st. So we have attempted to do that. If there's a disagreement that staff has on our suggestions, that's perfectly understandable. But we have done precisely that, Mr. Rennie. We also submitted a letter at 5 o'clock on September 22nd, last Friday, on this revised ordinance with as best we could an attempt to, again, be very specific. So if we have a disagreement over how to resolve them, I can appreciate that. But I think we have, in fact, done exactly what we've been asked, is to give very specific amendments.
Are you referring to the September 18th letter?
September 18th letter.
Which says that remove the prohibition on behested payments.
Correct.
Is that what you're requiring?
Correct. And then it talks about disclosure language, it talks about the volunteer board members, et cetera. So we did do that, and sort of respectfully, maybe staff had a different approach. We can appreciate that. But we have attempted, and we will continue to do that.
All right. I didn't get page 1, so I don't know what he's referring to. May I have a recapitulation of what's before us now? A motion to
have the staff
remand this to staff.
For the staff to meet and discuss with Commissioners Chu and Lee.
All right. I'll vote for that motion.
Very well.
And no other motion.
Very well. Any further public comment on the motion? Okay. We'll vote. All those in favor of the motion?
Aye.
Aye.
Those opposed? Motion passes unanimously. Okay. Plug on.
I assume this will be on the agenda for the October meeting?
Yes. Let's see, where's mine? Okay. We'll move now to item number 5, discussion of staff policy report and monthly update of the Commission's annual policy plan and their attachments. Mr. Kundert will address that.
So I will keep it fairly brief regarding agenda item number 5. I do want to make a couple highlights on agenda item 5, page number 2 of that agenda item. Again, going back to the Ethics and Sunshine training, we had been contemplating and are working on a regulation related to Ethics and Sunshine training, and also attempting to revise some current regulations as it relates to that training and how it also assists us related to what we hope is e-filing for all, eventually for all Form 700 filers. We have been working on that regulation with the pending, or with the previous, pushing the last item back. Those regulations will probably get pushed back a little bit. But I just wanted to highlight that we are still working on regulations, attempting to bring forward to you that will sort of update the provisions of Ethics and Sunshine training to bring those in line with the Form 700 requirements, just so sort of all those good ethics trainings and open government trainings are occurring on a yearly basis, and they're sort of reinforcing our ability to review conflict of interest laws. Another item that I want to point out, and so we had a request from the FPPC to review Assembly Bill 249. We got that request 2 weeks ago. We were considering that. We have subsequently been told that it is not certain for signature now. And I also want to update you that along with that, we received roughly 11 items that the state legislature has enrolled, and a couple that were signed by the governor and chaptered that affect potentially our commission. As you know, the session is now over, so very late in the session, most were enrolled after the 13th of September. So staff has not had a chance to read and analyze all of those bills, but we were hoping at October to bring an analysis of those most pertinent bills and how that may affect us to you. But again, uncertain whether that will be the case currently.
Mr. Chairman?
Yes.
Commissioner on that issue, I intended to make a statement which I'll incorporate now. I'm surprised we haven't been informed of relevant state legislation. I asked Mr. Chairman that staff be instructed to inform us on a continuing basis so that we may, if we so desire, express publicly a position and convey that position to the relevant legislators. And in this case, here's Assembly Bill 249, which seems worthy of support, and I would have liked to have had a letter to the governor supporting it. But I'm not going to go through that Sunshine Task Force, whatever it is, Sunshine Ordinance Task Force business again, because it's not on the agenda. We should have a continuing report every meeting that the legislature's in session.
Ms. Bloom and Mr. Kundert, would that be a problem in regard to having a system of in place?
Yeah, we have that already in place as part of our document, so I apologize. We were trying to wait just because of the comprehensive nature of those to bring them in front of you when they were at a stage in conference committee when we thought it was going to be appropriate for you to consider them and have time. But again, with the end of the legislative session, they quickly passed bills that had been sitting unmoved for months, if not years in some case. So it was a surprise, and I do apologize, and we will certainly bring that forward and are prepared to do so at the next meeting.
Okay. I'd encourage you to stay on top of that, just like Commissioner Kopp has suggested.
And may I ask,
Please.
City Attorney Andrew, a question? Is this technically on the agenda? Because it's in the policy report? Could they vote to write a letter based on something that's in the policy report?
Is this going to get us before the Sunshine Ordinance
Well, I mean,
Task Force again?
Yeah, but I mean, just even more practically, I mean, I assume most of the commissioners would like to have a little bit more background on the proposal, which I'm not sure we're necessarily in position to sort of summarize at this point. And likewise, I assume the commissioners would like to see the text of the letter before it's sent out, which maybe we're not quite in a position to do, so it's more practical constraints than anything else.
Okay, so maybe we could bring back a letter next month with a analysis if it doesn't pass. A proposed letter? Oh, it's going to be too late? Okay. All right, never mind. Thought I had a solution.
Good thought, though. Very good thought. Yeah. Just sort of, if you, it sounds like you're on top of it. They moved too quickly towards the end of the session, but Commissioner Kopp has an important point. We should know about that stuff so we can give our input.
I don't believe I have anything further, just then to say, again, we hope to, in our upcoming projects, start the sort of comprehensive review of the Conflict of Interest Code, and along with that, the sort of comprehensive view of the Campaign Finance Reform Ordinance regulations. Obviously, if anything is passed in front of this body at a future meeting, and also I don't believe the regulations have been reviewed for some time, that we're going to need to update those regulations to match anything that we pass. And also there's been a number of campaign finance related bills that have passed in recent years, and I think we need to reevaluate some of the regulations and whether those are still accurate and pertinent and in place. So those are sort of the two large pending projects that will be pushed off for another month or so. That is all I have.
Any commissioners, any further comment? Any public comment on so we'll move now to item number 6, discussion of the enforcement report, an update on various programmatic and operational highlights of the enforcement program. Ms. Bloom.
Yes, thank you, Chair. The enforcement report, as usual, contains a number of statistics regarding our open complaints and preliminary review matters. It also contains information about ongoing efforts by the Bureau of Delinquent Revenues to collect outstanding fines and penalties owed and payment installment plans. The predominant substantive enforcement update I have is this month we conducted 2 interested persons meetings on our proposal to revise the enforcement regulations. We conducted those interested persons meetings based on concepts and got a number of good ideas from members of the community. A total of 4 people appeared at the interested persons meetings. But they provided excellent substantive comment, and so we're working those into our ongoing draft, and we hope to have draft out for public review next week when Director Pelham is back and has had a chance to look over the final. And that is all, unless anybody has questions.
Commissioners? Yes, Commissioner Chu.
So, in looking at page, I believe it's 2, Table 1, we now have a total of 47 pending formal complaints as of September 19th. Was there an increase from last month? I don't recall the exact number.
Yes, we opened, I believe, eight new investigations and dismissed 27 complaints. So the preliminary review numbers are down as well. And just as a matter of, for your information, they're under 90 now as of today.
Oh, congratulations. Would it be possible to add a column? So we have a new total number, but for us to be able to see on a month-over-month basis, to see where we are as of August, and then which and what has been and how many are new. You don't, and possibly by category as well.
Sure, I include that statistic in writing in the very opening paragraph,
Okay.
but it's an excellent suggestion to include it by category, so I will do that.
Any public comment on, I'm sorry, Commissioner Lee.
I have to sit closer to you. Thank you, Mr. Chair. And through the chair, I have a question. For the penalty installment program or plans, is there a formula that you have to follow? Like, for instance, do they have to make a minimum percentage? Or because I'm noticing some of the amounts are like really, really small. So the administrative cost of processing it every month will supersede the amount that you're getting. So is there a reason why they are so low and it takes so long? Is there a legal reason that we have to do it this way?
I cannot comment on the decisions that were made represented here. These were past installment agreements made prior to Ms. Director Pelham's and my arrival. So this has been an ongoing installment plan for a very long time. You can see she makes $50 a month, and she's had about $3,000 total to pay off. So it's been a long time. But for your information going forward, I do not intend to accept installment plans unless there are countervailing circumstances that are demonstrated through evidence of inability to pay. And for the most part, if a payment plan is necessary, that generally means that the defendant cannot afford to pay the penalty, and so I'll conduct a fact assessment of their finances to determine how much they can afford to pay, so the penalty is appropriately deterrent and also doesn't affect their constitutional right to be free from unnecessary or burdensome debts from the government.
Thank you.
Any public comment on the item?
Good evening, Chair Keene and Commissioners. I just noticed, I think it's a typo, on the report, which is item 6, on page, it doesn't show the page, where it says revisiting ethics enforcement regulations for the phone number. It gives the area code 252.
Oh, thank you.
Okay.
Oh, thank you, Ms. Garfield.
All right.
So that'll be corrected. Any further public comment on the item? No, so we'll go to item 7 then. Discussion of the Executive Director's report. Executive Director Pelham is not here. Ms. Bloom, do you want to address that?
Certainly, thank you, Chair. First, Director Pelham notes that she and our Electronic Disclosure and Data Analysis Manager, Stephen Massey, met with the Cal Access representatives who are from the Secretary of State's office. They're considering revisions to the database for reporting and disclosing state campaign finance statements, and they're intentionally reaching out to local offices to try and figure out a way to make all of our systems either talk or at least complement each other instead of the sort of standalone and independent nature of the systems now. We felt that meeting was very productive, and we have hopes that we get a good system out of this process. We also welcomed Gayatri Takandil to the Chief Programs Officer on September 11th. She started as her official first day, and she's already hitting the ground running and doing a great job, so we look forward to future updates from her in the form of an engagement compliance report. Otherwise, as you know, we've got a number of vacancies open. We were able to post some of those positions for hiring this month. A lot of these positions are new positions that were authorized in our budget, and because of a civil service budget rule, we are not authorized to fill those vacancies until 3 months after the beginning of the fiscal year, which is September. So we're really pushing now to get all of those positions posted now that it's September.
Commissioners, yes, Commissioner Chu.
Is there an ETA on when we might expect to have these positions filled?
We are very optimistic that we can fill them by the end of the year. That's when our
them?
contract with DHR runs out.
So we hope to fill all of these positions? by the end of the
Hopefully,
year?
or at least
End
be
of the calendar
substantially
year.
on the way.
Okay. Great.
Any public comment on this item? We'll move to the next item, discussion and possible action regarding status of complaints received or initiated by the Ethics Commission. Commissioners, is there any reason anybody sees to go into closed session on this?
No.
Hearing none. Any discussion or on the matter from either the commission or the staff? Any public comment on this item? Okay, we'll then move to item number 9, discussion and possible action on items for future meetings. Commissioners? Yes. Ms. Bloom, I'm
yes,
sorry.
thank you. Sorry, I wanted to remind Commissioner Lee that she had a question about meetings. Yeah.
Oh, okay.
Time has moved so fast. My colleagues, when I first joined this commission, I knew the times required, not only to attend the meeting, but also to review and everything else, and I'm fully committed to it. However, recently, because of my mom's deteriorating health and the crazy way her worker schedule is, oftentimes I have to be home by 10:30 to relieve her workers. So I was wondering whether we can put a proposal for the next meeting for public discussion, if we can move the meetings, the commission meetings, to a earlier time. Maybe a different day, I don't know, but if we can entertain that as a possibility.
Commissioners, any thoughts?
I'm certainly open to consideration of changing the meeting from 5 o'clock, 5:30, but I assumed that the reason why they had set this up was because of the availability of the public TV only at this time, but I don't know. I could be wrong.
Yeah, are there any requirements in terms of timing that we need to adhere to in scheduling our meetings?
Yeah, so, right, we can certainly have a fuller discussion of this. We can basically the commission can change its regular meeting date and time. That's subject to a couple things. One, and I was just talking to Deputy Director Bloom about it, is one, we need to check that a meeting room is available. And as Commissioner Rennie pointed out, that meeting room is hooked up to SFG TV. Not all hearing rooms have TV broadcast capability. But if we have some flexibility in those two fronts, it would really just be a change to the commission's own bylaws. I can't recall the notice that's required, but we do need to provide a little bit more advance notice when we're thinking about changing our regular meeting date and time. Do you know the answer?
3 weeks. So 3 weeks' time, we have to notice a meeting change. So what we could do is next, like procedurally, we could research the times that are available in the city hall with those conditions, availability, room availability, and SFGov TV access, and then bring back a proposal to amend the bylaws accordingly with some options for times and dates in October for you to vote on in November.
Should that be a public agenda item for the public to comment?
Definitely, yes.
Okay, so we'll have that on then for our next meeting. discussion on that? Okay. Any
I have
Commissioner Collins?
an inquiry of staff as to the status of legislation unsuccessfully prosecuted at the Board of Supervisors by Supervisor Farrell. I haven't seen that yet, and it's been several months. And number two, I think 3 months ago, I transmitted to the executive director a proposed ordinance from Supervisor Safai. Has anybody on staff met with Mr. Safai or his major domos?
So I think that staff has been waiting for endorsement by the commission, the remainder of your commission members for that type of activity. I know Director Pelham has reached out to the chair on that regard.
I thought he called me, he contacted me for the commission to adopt it.
Mr. Safai, sorry. I have no knowledge of Mr. Safai contacting the commission.
I'm sorry, was I supposed to, you're saying, was I supposed to meet with or
Well, we haven't,
contact?
so staff hasn't pursued these additional ordinance requests until the full panel of the commission asks us to, is basically what we're waiting for.
So what are the ordinance requests?
One is to consider adopting an ordinance by Farrell regarding that Supervisor Farrell unsuccessfully attempted to introduce at the Board of Supervisors that would prohibit developers from using money that they received through city grants in order to, or loans in order to construct the development as campaign cash on the end. So they call it a pass-through. So
They don't pay it back.
Right, they would pay it back instead of using it for campaign contributions. And the other is a proposal from Mr. Safai, and I'm not even entirely sure what that proposal is regarding. Might be public financing?
That's on public financing funds from the city treasurer to candidates who then do not use or account for remaining funds.
So Mr. Kundert has met with all of the supervisors, I believe, and is in or at least most of them.
Pardon me?
And is in discussion with them about different proposals.
What's the status of that?
I believe we're trying, if, to the extent that we are considering anything from Mr. Safai individually, it's going to be rolled into the larger public financing discussion that is scheduled on the annual policy plan. So if you look at Mr. Kundert's policy plan, there's a table on the back that identifies when staff is going to undertake a comprehensive assessment of our public financing program. And I can tell you in just a moment when public financing is up. It's under staff review in July and August, tentatively also in staff review until December, and proposed to be at the Ethics Commission in January. So in January, you should tentatively expect to be seeing a proposal from staff with recommendations and analysis of our current public financing program and proposed changes if we think they're necessary. Is that accurate?
Yeah. Accurate, but for some of the changes in today's, just all these things get pushed back, obviously, pending this other stuff. I think an alternative request that we could have is that we simply bring these for review, since it seems that the commissioners haven't even seen the language of the ordinances. Yeah, I think we could bring them to them to see. So I think it's appropriate for us to, and perhaps at the next meeting, just give you a copy of those ordinances, but we haven't analyzed those failed ordinances in any regard.
So, Mr. Kundert, to be clear, these are failed ordinances that were proposed, sponsored by Supervisor Farrell and one by Supervisor Safai?
The Farrell one was a failed one, but the Safai one, I'm not sure if it was failed or even ever drafted.
Not drafted, just an idea.
Okay, so we'll have copies of those ordinances before us next time for any action that we may want to take.
Sure.
Yes, Supervisor Chu. Commissioner Chu, excuse me.
I've been elevated.
Demoted you.
Demoted, right. I do like, Deputy Director Bloom, the idea of rolling in. I mean, if there's not an actual piece of legislation that is pending that we need to comment on, but to take a comprehensive look within the overview of the policy priorities for the coming year, I think that is the absolute way to go about doing it.
Any public comment on this item? Okay. Additional opportunity for item 10, additional opportunity for public comment on matters appearing or not appearing on the agenda pursuant to Ethics Commission bylaws, Article 7, Section 2. Is there any such public comment? If not, I'll entertain a motion to adjourn.
So moved.
Second.
Oh, wait, I think I was too quick. Mr. Bush is not going to disappoint us as usual.
I just wanted to bring to the attention of the commission the op-ed piece by Anne Ravel about the need to address campaign material that misrepresents information. It's essentially about the Russian hacking. And she has a very strong and good piece in the Chronicle that appeared this week, and it was backed by an editorial from the Chronicle. She's calling for legislation to be done in San Francisco. It may be something that will become part of what Supervisor Kim is looking at, because she's looking at a general disclosure legislation, and I think that the commission staff is working with her office as well, but I just want to make sure that the commissioners are aware of that. Thank you.
Thank you, Mr. Bush. We have a motion to adjourn and a second. All those in favor?
Aye.
Any opposed? Motion carries unanimously. We're adjourned.